Mr. Clerk, for items for the record.
Thank you, Mr. President. New resolution LR 335 offered by Senator Michaela Cavanaugh. Accompanying that resolution, a communication from the Speaker referring the resolution to the reference committee. That's all I have at this time.
Mr. Clerk, next item on the agenda.
Next bill, Mr. President, general file, LB 1074, offered by Senator Slama. It's a bill for an act relating to banking and finance to adopt updates to federal law relating to banking and finance, change provisions of the Security Act of Nebraska, the Commodity Code, the Credit Union Act, eliminate obsolete provisions, harmonize provisions, repeal original sections, and declare an emergency. Bill was introduced on January 9th of this year, referred to the Banking, Commerce, and Insurance Committee. That committee reports the bill to general file with committee amendments attached.
Senator Slama, you're welcome to open on LB 1074.
Thank you, Mr. President, and good evening, colleagues. Today, I'm asking for your green vote on LB 1074. LB 1074 is a Banking, Commerce, and Insurance Committee priority bill. It's a bill that will update a number of banking-related statutes. So I'll briefly break down the bill's nature into 5 categories. The bill contains the annual reenactment of the Depository Financial Institutions wildcard statutes to provide equal rights, powers, and privileges for state-chartered banks, credit unions, and savings and loan associations with their respective federal counterparts. Updates will be to January 1st, 2024, so we're simply updating dates here. The bill updates references to specific federal laws and regulations affecting most of the entities under the jurisdiction of the department, including financial institutions, financial entities, securities, firms, and their representatives and agents, for which the reference date is currently January 1st, 2023. The updates will be, very groundbreakingly, to January 1st, 2024. The bill amends the Credit Union Act to change the designated official to whom the department sends a copy of its examination report in order to better protect the confidentiality of the report. The bill updates the Securities Act of Nebraska in the following ways. It amends Section 81116, which authorizes the department to petition for judicial appointment of a receiver of the assets of a person violating the act. Existing law provides that the director shall not be required to post a bond. This amendment would provide that neither the receiver nor the department would be required to post a bond. We also amend Section 81120 to remove obsolete language relating to prior year's transfers from the Securities Act cash fund. Finally, the bill amends Section 81726 of the Commodity Code, which provides for a civil penalty, fines, and costs for violations of the code to harmonize and clarify those terms. Again, I would appreciate your support for this important bill. Thank you, Mr. President. I can now open on the committee amendment if you're so inclined.
You may continue with the committee amendment.
Thank you, Mr. President. Good evening again, colleagues. AM 2560 is a committee amendment to LB 1074. This amendment contains the provisions of LB 1074 and also the provisions of 5 other bills that were heard by the Banking, Commerce, and Insurance Committee, all of which were made a part of this committee amendment on an 8-0 vote. I'll now go around the room to have each bill's original introducer and qualified substitutes provide an introduction on their bill. And that will start with me and LB 1075. LB 1075 will change provisions of the Delayed Deposit Services Licensing Act, the Nebraska Installment Loan Act, the Nebraska Installment Sales Act, the Nebraska Money Transmitters Act, and the Residential Mortgage Licensing Act. For those following along at home, that's section 48 through 50 and 68 through 76 of AM 2560. LB 1075 applies to consumer finance licensees, non-depository financial entities. There are two sets of changes for these types of entities found in the bill. The first are those related to data breaches. All consumer finance licensees, namely money transmitters, installment sales companies, mortgage bankers, installment loan companies, delayed deposit servicers, and installment loan companies, would be required to notify the department directly when they suffer a data breach involving the personal information of a Nebraska resident. This notification would be required within 3 business days of the data breach, with an exception where a law enforcement agency determines that such notice could impede a criminal investigation. The second set of changes are those related to background checks. The various acts governing the consumer finance licensees currently require background checks of insiders. The bill would make the process uniform by requiring the submission of fingerprints to the FBI with the nationwide mortgage licensing system, NMLS, serving as a channeling agent for the department. The Money Transmitters Act and the Delayed Deposit Services Licensing Act already contain the requirement. I'll now pass the mic off to Senator Ballard so that he can introduce LB 1122.
Senator Ballard, 8 minutes.
Thank you, Senator Solomon. Thank you, Mr. President. LB 1122 is included in the committee package. This is a basic amendment to increase the fines for violating Nebraska revised statutes 8-2501 and 8-2505. The violation of fines increases from 1,000 to 5,000. This section of statute deals with a person's ability or organization's ability to use a name, trade name, logo, or symbol of a financial institution without the institution's permission. These violators will use the financial institution's information to solicit business from customers who think the solicitation comes from the institution itself. There's been an increase in these occurrences, and so increasing the fine will hopefully provide an adequate deterrent from this occurrence. With that, I'd like to yield my time back to Senator Slama.
Senator Slama, 9 minutes.
Thank you, Mr. President. I will change my approach to where I'm asking a question. I did put Senator Ballard on the spot where he had the potential to double yield me time, and that would mess up the entire introduction. So next up is Senator Clements with LB 872. Would Senator Clements be willing to yield to a question?
Senator Clements, will you yield?
Yes.
Thank you, Senator Clements. Would you mind telling us a little bit about your bill, LB 872, please?
I'd be glad to. I want to thank Chair Slama for adding LB 872 to this committee priority bill. This amendment prohibits the acceptance of central bank digital currency, known as CBDC, by state and local governments in Nebraska. This bill is written based on a model policy recommended by the American Legislative Exchange Council. I have recently been hearing about central bank digital currency and have been concerned about what a CBDC would mean for Nebraska. Central bank digital currency means a digital account issued by a federal agency of the United States, such as the Federal Reserve, that is made directly available to the consumer. A central bank digital currency would be processed or validated directly by that federal agency and not by your local bank. A main concern with the implementation of a CBDC is the invasion of financial privacy and personal freedom. A CBDC with a central ledger would allow the government to see all transactions by its citizens. It could be used to greatly expand surveillance by putting our financial records on government databases. That would allow the government to control the availability of finances and what you can buy or sell on approval criteria or social credit scores, such as exist in China. This amendment to LB 1074 allows Nebraska to push back on a federal CBDC by prohibiting state and local governments from accepting a central bank digital currency. I want to thank the Nebraska Bankers Association for suggesting this bill and for their position against a central bank digital currency. Thank you, Mr. President.
Thank you, Senator Clements. I appreciate that summary. Next up is LB 710. Senator Dungan unfortunately can't be with us this evening. He has also unfortunately appointed what he believes is a qualified substitute to introduce his bill on his behalf. Senator Jacobson, would you yield to a question?
Senator
Yes,
Jacobson.
I would. Oh, excuse me, Mr. Chairman. Mr. President, I would yield. Thank you. Well, thank you, Chair Slama, and thank you, Senator Dungan, for having such confidence in me. Well, LB 710 is titled the Public Entity Pooled Investment Act. I know many people probably question, what are we doing here? Essentially, when you're a public entity, your counties, your cities, any of your municipalities, school districts, etc., you're a public entity, and you're going to have funds that come in and out, and so you generally have checking accounts with banks and accounts with banks to be able to handle those transactions. Over the years, there have been two pooled entities out there that actually work with counties and other public entities to be able to take certain portions of their deposits and pool it and try to get them higher returns. One of the challenges with that is, of course, when you're at a bank, you either have that fully FDIC insured, or we pledge securities in our securities portfolio, devote it to those dollars, and then pledge it with a margin. And in addition to having our capital behind that deposit as well. So one of the concerns that's been raised is, as we start looking at new entrants into this market, coming in wanting to attract these deposits, particularly in this higher rate environment, are looking at a situation where they come in and take these dollars and invest them into today shorter term securities, primarily commercial paper, and provide higher returns, and then take a fee or a commission for handling that and try to generate income from that approach. The problem with that, of course, is how much risk are we putting in the hands of these individuals? So there were two material changes that were made in this particular bill. Number one, we're limiting the length of the maturity of commercial paper, which effectively is an unsecured loan to a larger corporation, to 270 days of maturity. By limiting that to 270 days, the longer you go, the longer you take the risk of it being out there, something happening with that company and having problems. We're also limiting their total investment in commercial paper of all the fund securities that they have to 50%, and we're also limiting them to only doing 5% commercial paper with any one issuer. The other part of the bill really deals with requirements relating to licensing that requires them to be licensed specifically for whatever activity they're doing, whether that's with the SEC or whether that's a Series 6 or Series 7 license. So that effectively, Chair Slama, summarizes LB 710.
Thank you very much, Senator Jacobson. I appreciate that summary, and for you substituting in for Senator Dungan. Senator Bostar, would you be willing to yield to a question?
Senator Bostar, will you yield?
Yes.
Thank you very much, Senator Bostar. Would you be willing to tell us a bit about LB 1294, please?
Absolutely. And thank you, Chair Slama and Mr. President. And good evening, colleagues. AM 2560 includes the provisions of LB 1294, the Data Privacy Act. The amount of online information collected about consumers has grown over the years. There is a data point for nearly every activity we do online. And since data collected by many companies in states like Nebraska is unregulated, these companies can sell, use, or share the data without notification or permission. Data privacy has grown increasingly important with the acceleration of generative AI, which is built and trained on more than 1 trillion data points. Unsurprisingly, consumers want more control over their data. LB 1294 addresses these concerns by providing robust, common sense consumer data protection. The Data Privacy Act provides consumers the right to know whether a controller is processing the consumer's personal data, the right to receive a portable copy in digital format of the consumer's personal data processed by the controller, the right to request deletion of personal data provided by or obtained about the consumer, the right to request a correction of inaccurate personal data, the right to opt out of sales and personal data, targeted advertising and profiling and furtherance of a decision that produces a legal or similarly significant effect concerning the consumer, and the right to appeal any refusal to take any action on any of the aforementioned requests. LB 1294 would also require a controller, which is a person or entity that would determine the purpose and means of which processing personal data, and would apply to any entity doing business in Nebraska that is not a exempted by size or type of personal data collected, to practice data minimization and take reasonable measures to ensure that data cannot be associated with an individual. The United States Congress has failed to enact any comprehensive national solution for consumer data protections. While we do have federal laws that deal with elements of consumer privacy, HIPAA, for example, they are limited in scope and sector. These narrowly tailored protections mean that an omnibus solution to privacy concerns across all industries has yet to pass. Because of Congress's continued inaction, states have now stepped up to address these concerns. Thank you, Mr. President. 15 states, as of 2024, have enacted privacy legislation, and several hundred privacy bills have been introduced into state legislatures across the country. Nationally, state privacy bills have been supported by consumer groups, tech companies, chambers of commerce, as well as banking and finance advocates. LB 1294 follows the same pro-consumer, pro-business approach as the Texas Data Privacy Act, which gives consumers more control over sensitive personal information, but without the legal complications and intricacies that states like California have enacted. The legislation gives the Nebraska Attorney General the exclusive authority to enforce the bill and does not afford a private right of action for violations under the Act. Additionally, LB 1294 provides guardrails for the release of vital records from state agencies. Nebraskans have shared increasing concerns about the amount of data that is not only created but is shared, analyzed, and stored by tech companies and other businesses. LB 1294 is a common sense proposal that will not only grow consumer trust but allow for data to be used in ways that are ethical, responsible, and innovative.
And you are next in the queue.
Thank you, Mr. President. LB 1294 was amended in the Banking, Commerce, and Insurance Committee priority on an 8-0 vote. I urge your green vote for AM 2560 as well as the underlying bill. Thank you, and I will yield the remainder of my time to Senator Slama if she needs it.
Senator Slama, 445.
Thank you very much, Senator Bostar. Between you and Senator Jacobson, I should have assumed that we'd be far too verbose for the 10-minute limit. But just to lay the table for the steps we have up next with the Banking Committee bills, again, every bill that's been attached to this Christmas tree came out 8-0. Opposition's been resolved. I'm grateful for the bipartisan work of the Banking, Commerce, and Insurance Committee. We have the committee amendment up next. And then after that are two amendments to the committee amendment. LB 1176 as amended by AM 2627. That's from Senator Dungan. Senator Jacobson will introduce that. Senator DeBoer also has a role in there and will be providing her summary of LB 1290. With the few minutes I have left, because if all goes well, I won't have to have too much of a close unless things really do go south. I would like to take a minute to thank my committee legal counsel, Joshua Chrysler, and committee clerk, Natalie Shunk, for their excellent work on the Banking, Commerce, and Insurance Committee this year, along with all of my outstanding committee teammates. I think we've really put together a banking Christmas tree this year that is worthy of being a banking Christmas tree and will make you feel festive just as a banking Christmas tree should. Thank you, Mr. President.
Mr. Clerk, for an amendment.
Thank you, Mr. President. Senator Dungan would offer AM 2820.
Senator Jacobson, you're welcome to open.
Thank you, Mr. President. 2820 actually incorporates what I'd visited about earlier on the pooled securities. It covers all those pieces. And then along with that, Senator DeBoer has an amendment that she brought into that as well. So I believe we'll be yielding time to her to answer that question as well. But while I have the mic, I too would like to compliment Chair Slama for the work that she did. She was a great leader, really helped us get through a lot of material. Really brought a lot to the table, and I appreciated her experience, particularly coming in last year with the brand new committee chair and the committee counsel, and we seem to be very seamless in the process. So I want to do a shout out for Senator Chair Slama for all of her hard work. So thank you, Chairman Slama.
Seeing no one in the queue, Senator Jacobson, you're welcome to close.
I'll yield time to Senator DeBoer.
Senator DeBoer.
Thank you, Mr. President. Colleagues, I can't be outdone on being verbose by the two gentlemen before, so I will now ask you to sit down and relax. No. I'm excited to introduce my portion of this amendment. LB 1290, which is section 74 to 79 of AM 2820 on pages 4 to 7. Thank you to the Banking, Commerce, and Insurance Committee for being willing to include this bill in their committee priority bill, LB 1074, and for Senator Dungan for including it in AM 2820. LB 1290 seeks to resolve an issue brought to my attention during the Supreme Court Commission on Guardianship and Conservatorship meeting this past December, of which I am a member. Individuals with disabilities living in nursing homes are given an allowance from their own money of $75 to cover all expenses not covered by Medicaid or Medicare. These expenses could be anything from clothing, shoes, mattresses, and non-covered supported devices like an electric scooter. If an individual qualified for an Enable account or had a first or third party special needs trust, they have the ability to pay for expenses greater than $75 in any given month. The existence of these Enable accounts or special needs trusts does not count against their eligibility for Medicaid or Medicare. For the transcribers, the acronym I'm going to be using is SNT for Special Needs Trust. Currently, it's unclear how a governmental agency determining eligibility for benefits should treat pooled SNTs. For some individuals, there is no issue at all, but for others, they have been disqualified for Medicaid or Medicare because of their pooled SNT. This is troubling to me. First, we should always strive to be consistent in how we handle eligibility for benefits, but perhaps more importantly, it's because of who this impacts the most. Pooled SNTs are most often used by elderly disabled individuals. Eligibility to Enable accounts is limited to those disabled before 26. A first-party SNT requires the individual to be able to administer the funds themselves, and a third-party SNT requires there to be a third party known to the individual with disabilities to administer the trust. But a pooled SNT is administered by a fiduciary nonprofit organization, making them useful to individuals with limited caretakers as options. LB 1290 will harmonize how Nebraska treats trusts for our special needs population and will ensure elderly disabled Nebraskans can cover small needs that remain unmet by their $75 allowance each month. We have talked a lot about wanting to be sure Nebraskans stay in Nebraska their entire life. I believe LB 1290 is an important piece of that puzzle. So thank you very much for including this in the Banking Committee package, and I would encourage your green vote on AM 2820, AM 2560, and the underlying bill. Thank you, Mr. President.
Colleagues, the question before the body is the adoption of AM 2820. All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
33 yeas, no nays on the adoption of AM 2820.
The amendment is adopted. Senator Slama, you're welcome to close on AM 2560. Senator Slama waives close. Question before the body is the adoption of AM 2560. All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
33 yeas, no nays on the adoption of committee amendments.
AM 2560 is adopted. Senator Slama, you're welcome to close on LB 1074. Senator Slama waives close. Colleagues, the question before the body is the advancement of LB 1074 to E&R initial. All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
Thirty-three yeas, no nays on the motion to advance the bill.
LB 1074 advances. Mr. Clerk, next item on the agenda.
Mr. President, Legislative Bill 1301, introduced by Senator Takei at the request of the governor. It's a bill for an act relating to real property to adopt the Foreign-Owned Real Estate National Security Act to change provision relating to non-resident aliens taking property by succession of testamentary dispositions, change provision relating to foreign ownership of real property, provide duties for the Department of Agriculture, the Attorney General, harmonize provisions, provide operative dates, provide severability, repeal the original sections, and to outright repeal sections 76-403, 404, 408, 409, 76, 410, 411, 412, and 415. Bill was introduced on January 16th of this year, referred to the Agriculture Committee. That committee placed the bill on general file with committee amendments.
Senator Kay, you're welcome to open.
Thank you, Mr. President. Good evening, colleagues. LB 1301 is my personal priority bill for the year and would adopt the Foreign-Owned Real Estate National Security Act. This bill was heard by the Agricultural Committee on February 6th and came out on a 6-0 vote with one present not voting and one absent. During the interim last year, several senators, including myself, got together to try to modernize Nebraska's existing foreign land ownership laws. We came up with two ideas, which ultimately resulted in two bills, LB 1120 and LB 1301. If you all recall from the debate on Senator Hardin's LB 1120 bill, his bill was a proactive part of the package meant to serve as a tripwire to go after concerning foreign land transactions. LB 1301 is the retroactive part of the package that looks at how we at how we do enforce our state's foreign land ownership restrictions and update the process to divest the land held by violators of our laws. The bill's basic intent is to modernize Nebraska's existing statutes pertaining to foreign ownership of land in this state, provide a mechanism for reviewing land purchases, and give the state, not counties, the ability to carry out divestment proceedings to enforce our foreign land ownership laws. According to the National Agricultural Law Center, approximately 24 states specifically forbid or limit non-resident aliens, foreign business entities, or foreign governments from acquiring or owning an interest in private agricultural land in their state. Nebraska is one of those states with existing laws on the books dealing with foreign land ownership, but many of these statutes have not been looked at or reviewed in decades. If you look up Chapter 76, Article 4, which is the section 76-404 to 76-415, you will see that other than a few minor updates, most of these sections were last amended in 1943. Obviously, it is not World War II anymore, and times of current threats to our national security, food supply, and agriculture sector have changed dramatically in the 81 years since these statutes were last updated. The centerpiece of LB 1301 is modernizing the enforcement mechanism of our state's existing foreign land ownership laws. Currently, county attorneys are tasked with enforcing our current statutes. When I visited with the Nebraska County Attorneys Associations in regards to their duties in Chapter 76, Article 4, I was told that they are hindered in what they can do to enforce these laws primarily due to time and resource constraints. LB 1301 would instead empower the Attorney General and the Nebraska Department of Agriculture to review whether a violation has occurred. If there is a reasonable suspicion, action can be carried out to divest or resell the property at public auction. These two agencies have more money, time and staff and resources to investigate violations and pursue an enforcement action when compared to any one county attorney in outstate Nebraska. For this reason, NACO testified in support at the hearing and agreed that NDA and the AG are more appropriate entities to enforce our foreign land ownership laws. Additionally, under this bill, those designated as restricted entities would be under heavy scrutiny, subject to greater restrictions to own land in Nebraska. There are two sets of federal lists referenced in the bill. The first series of lists of references that the sanctioned individuals or entities identified by the Office of Foreign Assets Control, or OFAC. The OFAC list covers of individuals and entities linked to terrorist groups or subsidiaries of certain foreign governments. The main list is over 2,000 pages long, while other supplemental lists exist for criminal groups, sanctioned invaders, and others. The second list referenced 15 CFR 7.4, which is the list of foreign adversaries designated by the United States Secretary of Commerce. The Secretary of Commerce currently designates Russia, the People's Republic of China, including Hong Kong, Cuba, Iran, the Maduro regime of Venezuela, and North Korea as foreign adversaries. By referencing federal lists, we are not just picking names out of a hat, and the lists allow our statutes to be adaptable, since threats to our country will no doubt change in the decades ahead. I also want to thank Senator Bolstar for this portion. He proposed that we added something being considered in Texas, which creates a mechanism for the Attorney General to report concerning non-notified real estate transactions in Nebraska to the Committee of Foreign Investment in the United States, or CFIUS. CFIUS reviews the national security implications of foreign investments in United States companies or operations before they can go forward. Now, I want to briefly touch on 4 key points in the committee amendment AM 2594. First, language was added to provide that designated restricted entities that have undergone the review through the CFIUS process can remain here under the section 76-411, manufacturing and industrial use exemption. These entities would be required to report their CFIUS status to the Department of Agriculture. However, the entities that have undergone the CFIUS process would not be allowed to expand their land footprint. This language makes sure we do not run afoul of existing federal laws which govern cases when the federal government reviews certain transactions involving foreign investments and acquisitions of American businesses and real property through the CFIUS process. Other states like North Dakota have also adopted similar language to their statutes. Second, the foreign agricultural landowners would be required to report to the USDA through the FIDA report form SA-153, or risk enforcement of divestment proceedings. This provision is already required by federal law under the Agricultural Foreign Investment Disclosure Act, or FIDA. But a key issue with this law is that the federal government has issues with enforcement. This language adds another tripwire to weed out bad actors and another layer of review to ensure that there is compliance with the federal FIDA law on the state side. If we ever need to obtain someone's FIDA information, our Department of Agriculture can communicate with the USDA. Third, language was added which reinstates the exemptions in section 76-404, 76-412, and 76-413. These sections contain exemptions relating to oil and gas leases, railroads, public utilities, common carriers, and municipalities. There are foreign companies operating pipelines in this state. Under federal law, in cases of pipeline spills, the EPA or other federal agencies may require the company to purchase land for remediation. Reinstating these exemptions would ensure Nebraska does not prevent those companies from complying with federal law. Restricted entities would be unable to utilize those exemptions in sections 76-404, 76-412, and 76-413 unless they can use the section 76-411 exemption by undergoing the CFIUS review. Fourth, the committee amendment.
1 minute.
Thank you. Fourth, the committee amendment on AM 2919 will bring the Nebraska Land Title Association, Farm Bureau, and other ag groups in a position where they are comfortable where this bill is at. DNI, the National Nebraska Land Title Association, initially came out in opposition to this bill at the hearing. Their initial opposition was technical in nature and concerned issues such as protecting real estate agents and county clerks from liability, as well as wanting process enhancements like notifying the pendency of action commencing divestment action in court. In summary, LB 1301 is not doing something which radically deviates from our existing statutes. Nebraska already has existing restrictions on foreign land ownership. My bill simply modernizes our statutes and clarifies the intent that our state wants more oversight and restrictions for foreign
Senator.
Thank you.
Senator Halloran, you're welcome to open on the committee amendment.
Thank you, Mr. President. Thank you, Senator DeKay, for carrying this bill, drafting it with the help of Senator Bostar, Senator Hardin. This is an important bill. Senator DeKay pretty much went through the committee amendment. I'm going to go through it again. Bear with me. It'll be maybe a little more technical. The committee amendment, AM 2594, is a white copy amendment which replaces the bill. The committee statement provides a detailed section-by-section explanation of the amendment, which correlates sections of the amendment to section of LB 1301 as introduced, including modifications to the original provisions and any new sections added or original provisions omitted. I'll try to give you an overview of significant changes. Section 4 through 20 of AM 2594 become the Foreign-Owned Real Estate National Security Act. The amendment continues to incorporate and update portions of Chapter 76, Article 4, which contains current restrictions on the foreign entity acquisition of interest in real estate in the state, to be responsive to modern-day national security concerns. Existing 76-402 remains as establishing a general prohibition against non-resident alien foreign business or government entities from acquiring ownership or leasehold interest in real estate except as otherwise permitted by the Act. AM 2594 would apply the restrictions of the Act to acquisitions that occur after the effective date, provided holders of interest have registered those holdings as required by the Federal Agriculture Foreign Investment Disclosure Act, if applicable. The amendment would restore two sections which were outright repealed by LB 1301 as introduced. Statute 76-401 currently states an exception to the general prohibition against foreign-held real estate interest to allow lease interest up to 10 years for oil and gas development. The other restored section, Section 76-412, currently excludes real estate interests held for construction and operation of railroads, public utilities, and common carriers. In both cases, these exceptions are reinstated but modified to provide that these exceptions are not available to restricted entities. Additionally, the amendment revises Section 76-414, which currently excludes real estate lying within or within 3 miles of a municipality from prohibitions against foreign-held interests. AM 2594 narrows this exception to provide that it is not available to restricted entities. The committee amendment also revises Statute 76-413, which allows interest held by foreign persons or entities for purposes of manufacturing or petroleum product distribution and retail. As introduced, LB 1301 would have denied this exception to interest held by a restricted entity within a restricted area. The amendment eliminates the geographic restriction in the original bill, but would provide that the exception does not permit a restricted entity to acquire new or expand existing facilities anywhere in the state, that any restricted entity holding are in compliance with any national security agreement with the Committee on Foreign Investment in the U.S. With this change, the definitions of restricted area and military installations become obsolete and are omitted. The amendment relocates investigation and enforcement provisions that were contained in Sections 6 and 12 of the original bill to Section 14 through 16. Section 14 contains the duties and authorities of the Attorney General under the original bill to allow the AG to receive reports of property holdings of concern by any person, removing the restriction that the report is limited to, quote, non-notified, quote, interests. Section 15 contains the purposes of Section 2 through 9 of Section 6 of the bill as introduced. The amendment retains a provision of the bill that vests the Department of Agriculture with authorities to investigate real estate interests potentially in violation of the Act, and concurrent authority of the department to retain counsel to initiate enforcement actions. The significant modification from the bill as introduced include: the amendment would authorize the Attorney General or Department of Ag retain counsel or subpoena witness documents and testimony to aid with investigations. Number 2, the amendment would authorize pre-litigation actions to notify any entities believed to be in violation and to allow entities to voluntarily divest such holdings except through sale or transfer to another restricted entity. An action to divest would be brought in the event the entity fails to respond or fail to divest. Number 3, a requirement is added for notice of pending divestment proceedings or court order divesting the property be recorded with the appropriate register of deeds. Number 4, remove that a portion of proceeds from the sale of property be paid to a person who reported real estate interest held in violation of the Act. The amendment would add that proceeds be applied to any taxes or assessments due. The amendment would add new Section 16 to provide that divestments ordered under the Act shall be by public auction within a year of the order and shall be conducted in a manner provided in the Nebraska Trust Deeds Act. Any purchaser would require or acquire the property free of any claims by or through the divested owner. Finally, the amendment would add 2 new sections. New section number 17 provided that a title of interest in real estate of a current holder is not invalid due to a previous owner in the chain of title being in violation of the Act. New section 18 provides that the parties to a transaction do not have a liability to determine whether a buyer or seller is in violation of the Act. I would ask for the adoption of the committee amendments.
Thank you, Senator. Senator John Kavanaugh would like to welcome some guests this evening. Corey Steckler from New York, Riaz Mohammed from Maryland, JP Isabel from Vermont, and Jason Billick from Minnesota. They are located under the south balcony. Please rise and be welcomed by the Nebraska Legislature. Mr. Clerk, for an amendment.
Thank you, Mr. President. Senator DK would move to amend the committee amendments with AM 2919.
Senator DK, you're welcome to open.
Thank you, Mr. President. AM 2919 is a cleanup amendment to the committee amendment. AM 2919 would do 3 things. First, the amendment makes the word list plural in reference to the sanctions list published by the Office of Foreign Assets Control. The committee amendment just referred to one singular list when there are actually multiple different lists published and maintained by OFAC. This change probably could have been done through an ER process, but I figured I would like to make sure it was not missed. Second, the language was added at recommendation of the Nebraska Banking Association to clarify that a copy of the petition is to be sent to any secured party who has a registered or filed lien, mortgage, or trust deed against the real estate, or filed a financing statement against the real estate as provided by law when a divestment action commences in court. Our initial language was okay. This change just adds more clarity for who gets a copy of the petition. Third and finally, the amendment would make it required to have receivers sell divested land in accordance with the Nebraska Trust Deeds Act. In committee amendment, a receiver may sell the divested land in accordance to the Trust Deeds Act. Where there is permissive process like what is in the amendment, it usually ends up becoming the de facto required method to ensure transaction. However, by making it permissive, we risk a receiver not selling the land in accordance with the Trust Deeds Act. That would be legal, but probably would not be insurable, so we could wind up with people that thought they had followed the process correctly, only to find out later that the insurance company does not like it. To put it simply, we could create a real mess with the real estate folks if someone deviates from the Trust Deeds Act. To make sure that we do not have these issues with title, underwrites, and insurability, we changed the word may to shall, to establish that the Trust Deeds Act is a uniform process to sell land divested pursuant to the Foreign-Owned Real Estate National Security Act. I would like to thank the Land Title Association for working with me with the committee amendment and this amendment to ensure everything brought up at the hearing is addressed and we can ensure a smooth process for everyone if a divestment action takes place. I would encourage a green vote on AM 2919. Thank you, Mr. President.
Returning to the queue, Senator Hardin, you are recognized to speak.
Thank you, Mr. President. I stand in support of AM 2919, 2594, 1301. And I appreciate Senators Decay, Halloran, and Bostar for all of their work during this interim that took place, because it was a lot of work. It sounds like an easy thing to say, simply keep hostile foreign actors out, and unfortunately it is not easy. So we also deeply appreciate the work of the Policy Research Office and their help in synthesizing all of this. And so just want to appreciate all of the work that went into this for a very long period of time. And with that, I would like to yield the rest of my time back to Senator Decay.
Thank you.
Senator Decay, 4 minutes 12.
Thank you, Mr. President. Thank you, Senator Hardin. To finish up where I started on my opening, the summary part of it. In summary, LB 1301 is not doing something which would radically deviate from our existing statutes. Nebraska already has existing restrictions for foreign land ownership. My bill simply modernizes our statutes and clarifies the intent that our state wants more oversight and restrictions of foreign adversaries, especially when we consider our state's role in our nation's agricultural production and housing critical military installations such as the Panhandle missile silos. This bill just makes sure if a physical land threat does come up in the future, the state can actually take actions, since right now we really cannot do that in outstate Nebraska. I would like to give a special thanks to Quinn Kazemius in Bill Drafter's office for his patience in helping my office with amendments and drafts in the last 9 months. I would also like to thank the members of the Ag Committee for their assistance with this bill and the committee amendment. Thank you.
Senator John Kavanaugh, you're recognized to speak.
Thank you, Mr. President. And I'll ask Senator Decay a question in a second, but I just wanted to take this opportunity to reiterate the welcome to my friends from the Vermont Law School, which some of you may know I attended, the Fighting Swans, located in South Royalton, Vermont. And some of you know the origin story of the Vermont Law School, but I won't go into it now. But if you'd like to either ask one of my friends or I'll tell you about it another time. It's a pretty good story. But so they came into town for the NCAA tournament in Omaha, which of course is a great form of economic development. We're bringing folks in from all over the country to come watch basketball. So out-of-state dollars being spent in Nebraska, but they wanted to come down, have an opportunity to see the legislature after dark. So welcome to Jason, Corey, JP, and Riaz. If you have a chance, go say hi to them. But would Senator Decay yield for a question?
Senator Decay, will you yield?
Yeah. Yes.
Thank you, Senator Kay, and thanks for bringing this bill. And you and I had a chance to just chat off the mic, and I actually think you did cover this, but just sometimes it's helpful to have a conversation about it to clarify. So on page 4, carrying over into page 5, there's this new language for striking out 76402, and it says a non-resident alien who is not a citizen or national of the United States or foreign corporate, who is not a citizen of the United States, comma, a foreign corporation, comma, a government other than the United States government, or a government of its state, political subdivision, territory, or possession, or its agent or trustee or fiduciary thereof. And then it goes on to say, shall not acquire title to or take any real estate or leaseholding interest. And then there's other parts. But my understanding of your bill, the intention of the bill is only to ban these foreign adversaries from purchasing land. Is that correct?
Exactly.
Okay. And you and I talked about this. I think there's a potential reading of this language that would say it would be a ban on all folks, including foreign-owned companies like, say, I don't know, Smithfield or something like that, or just foreign-born non-residents but non-citizens of the United States. But that's not your intention.
No.
So, and I spoke with committee research analysts about this, and if at this point, if in between now and select, if it does look like it needs clarification, are you willing to entertain an amendment that would clarify that that's not what this bill is supposed to do?
Absolutely.
Okay. Well, I appreciate your work on this. Thank you, Senator Kay. Thank you, colleagues, for indulging me about introducing my friends. And I think I do really appreciate the work of Senator Kay, Senator Bostar, the committee on this. This is, if you haven't read it, it is dense, complicated stuff. I appreciate Senator Kay working to update some of the anachronistic language that was in this bill, and him undertaking that kind of work. I do think wrongfully subjected him to some maligning in the hearing I heard about. And so I'm sorry about that, Senator Kay, that somebody took that the wrong way. But you don't have to wait for me to ask you more questions. I'm pontificating now, but I appreciate your work on this. This is important stuff. And with that clarification, I would support AM 2919 and 2594 and 1301. Thank you, Mr. President.
Senator Takei, you are recognized.
In response, one thing that we did do, according to the questions that Senator Kavanaugh asked me, this is an example of what happened in Florida. In a recent case law, there is an ongoing case in Florida, Shin versus Simpson, where 4 plaintiffs argued that the state's newly enacted foreign ownership law violates the United States Constitution. The U.S. Court of Appeals for the 11th Circuit ordered an injunction on 2 plaintiffs and allowed the bill to be enforced on the other 2 plaintiffs. Now, Florida did 2 things wrong. First, they called out countries by name without any rational basis, and in this case, it was China. Second, the most recent decision, Florida law attempted to preempt federal government's authority to review transactions through the Committee of Foreign Investment in the United States. The lack of a CFIUS exemption is what ultimately got the injunction for the two of the plaintiffs, though I should note the injunction is limited to 2 individuals, which means the state may continue to enforce its restriction against all other investors subject to their foreign ownership law, including the Shin plaintiffs. I am not a lawyer, but my impression is if an injunction is issued, that pretty much shows where the court is going to land in the end. The fact the injunction just applies to those who made the CFIUS claim shows these laws should be able to stand up to scrutiny. LB 1301 first references federal lists, so we didn't come up with names out of thin air. And second, the bill does not preempt CFIUS. Therefore, we should not run the issues like the ones that were raised in Florida. Thank you.
See no one in the queue. Senator Takei, you are welcome to close on AM 2919. Senator Takei waives close. The question before the body is the adoption of AM 2919. All those in favor vote aye. All those opposed vote nay. Mrs. Clerk, please record.
39, excuse me, 39 ayes, no nays on the adoption of the amendment.
The amendment is adopted. Mrs. Clerk, for an amendment.
Senator Wayne would move to amend with AM 3095.
Senator Wayne, you're welcome to open.
Thank you, Mr. President. Thank you, Senator Decay, for allowing me to amend this on your bill. That was a joke. Nobody's laughing. All right, Nebraska owned, Nebraska led. That's what Governor Pillen said in his state of the speech while talking about referring to Chinese companies buying all Nebraska land. When it comes to the future of home ownership, I think having people outside of Nebraska buy land, particularly investors and hedge funds and LLCs, are causing a huge problem in least Omaha. I also heard the term this year, East Coast money, when talking about to invoke fear about how Omaha is losing to other people buying property. So I want to tell you a little bit about a company in Omaha, well, not in Omaha, Vinebrook Homes. They created a problem. They bought a couple years ago 1 in 5 homes in Omaha that were up for sale, many of them under $2,000. Over a 2-year period, the Ohio-based company called Vinebrook Homes went on to gobbling up 153 homes in my district and Senator McKinney's district, almost all of them in North Omaha. They are the biggest landlords now in the state, and they do not live here. This company owns about 27,000 homes that are now in perpetual rentership. If you think about that, we have to stop this invasion of driving up our affordable housing. So when I saw this bill come up on the floor about foreign ownership, I thought, well, clearly this is germane. This deals with home ownership and foreign entities from foreign states. So this is real simple. The bill is not even a paragraph long. It just says that you have to be a domiciled company in Omaha or a person in, not Omaha, in the state of Nebraska or live in the state of Nebraska to own a single family home. Not really complicated. It is a simple bill that I think we need to address because actually during the testimony, there were 2 young individuals who came into the committee hearing, and they were actually doing a study of a Lincoln neighborhood. And what they found out in the Lincoln neighborhood over the last 10 years is that almost all of their rental properties are single family homes that were being bought were by LLCs, many of them foreign LLCs, who are now turning this into rental properties. But the problem is when they're buying these houses at a certain price, they're buying them typically above market, typically way above market, driving up the homes for everybody. So this is an issue, and they're walking in and paying cash. And so this is an issue where we'll find in a lot of these in East Omaha and in some of the areas in Lincoln that we are seeing these out-of-town companies who are coming in and buying up all the affordable homes, charging higher than market rate rents and driving people out of affordable housing. So I put this on there to maybe have a debate to talk about it. I think it's important. I look for your support of this great amendment. Senator Decay has toured the area and seen many of the houses that we're talking about. We need to fix this problem. Thank you, Mr. President.
Senator McKinney, you're recognized to speak.
Thank you, Mr. President. I support AM 3095 for all of the reasons Senator Wayne mentioned. I get calls, and a lot of times when I talk to many homeowners in my community, they tell me about the frequent calls they get from random people out of state that call them constantly. Hey, are you trying to sell your home? Hey, are you trying to sell your home? Hey, are you trying to sell your home? And it just happens and happens and happens. And then you talk to other people and they say like, yeah, like this person that I'm renting from does not even live in a state, and I'm having issues and I don't know how to address these issues because the person that I'm renting this property from is not a resident of the state. They're not even from Nebraska. I really don't even know where they're from. So this is why I support this amendment, because we have too many people that are buying up property And what I would say in high poverty areas or areas where properties have been devalued for a long time and people brought those properties or purchased those properties at probably low prices and are renting out those spaces and now are hiking up the rents at prices. And if you look at some of these houses, and I talked to some of these people, and they're like, "Oh, my rent is like $1,300 or $1,500," and you look at the house, and you're just like, "It's no way that you're paying $1,300 or $1,500 for that house." And it's no disrespect to the people that live in the house. It's just the house is just not worth paying that amount of money for a month. It's just ridiculous. So that's why I support this amendment, because part of our housing crisis is people like this and investors and firms and investment companies. And it's not just a problem in the state of Nebraska, because I go down YouTube dark holes a lot of times when I'm home after I leave here or just after a late night, and you'll see that this is a crisis across the country where investment firms are buying up large swaths of property and then renting out those spaces, whether for Airbnbs or just rent them out, and they're just raking up the prices and causing problems for the housing market. So I think everybody should support this amendment, because it might not be an issue in your community today, but if we continue to allow this to happen, it will be an issue in your community tomorrow. Thank you.
Senator Vargas, you are recognized.
Thank you very much. I rise in support of this amendment for a couple different reasons. And one, I do hope people support it. We in the planning committee, we've looked at a couple different data points. One of the most interesting thing that came out of the planning committee this last year was the inventory that we currently have right now across the state of homes for sale. So in August of 2023, 4,718 homes were for sale in Nebraska. This represents a 12.1% decline from the previous year. What this basically means is this 1 month of supply of homes for sale is significantly lower than what we would consider a healthy housing market across the state. Nebraska is one of only 4 states in the nation with only a 1 month supply of homes for sale. So this is as a result of homes being bought out by out-of-state companies, sometimes foreign-owned companies. People can't compete with cash offers. It's reducing our housing stock, which is increasing the cost of housing across the state, increasing housing prices. That means that we can't keep up, and we're forcing rental owners to continue renting, which means we're forcing people that do not have an option to have a piece of the American dream and have an owner-occupied home. I just want you to remember, the first home that you had was the first piece of equity. You used it, you leveraged it for maybe a small business. You can refinance, it can pay off some debt. It is the first thing that you have. And we are saying that, well, this is a very simple bill, making sure that we are keeping housing available and not allowing out of state, out of country individuals to purchase it or have it domiciled within the state if they're purchasing it. I think this is a good bill. Again, that data is from the report that came out from UNO that was also shared with the Planning Committee, where we are one of 4 states in the nation with only a 1 month supply of homes for sale. At this time, we are in the bottom 5. Vote green on this amendment. Thank you.
Senator Jacobson, you're recognized.
Thank you, Mr. President. I remember when I was a kid, I used to watch a show on TV. It was called The Twilight Zone. I believe we're back. We're here living it right now. We're in the Twilight Zone. I have never heard of a more ridiculous idea than what this is right now. I mean, you've got to be kidding me. We're going to tell people that they can't sell their home for more than somebody else thinks it's worth? Do we live in America? What are we thinking? Yes, there's a housing shortage. We've been screaming about that for some time. That's why we need rural workforce housing, middle income workforce housing. That's why we need TIF. That's why we need incentives, because the cost of housing has gone through the roof. And you could go to Washington and ask Mr. Biden why that's happening. It's because of inflation, and it's because of the pandemic. But we're not going to come in here and say that capitalism no longer applies. That's not the answer. You can't tell me, as Senator Vargas said, people buy their first home, and why do they buy it? Because they expect the value to go up, and they build equity. If the government comes in and arbitrarily determines what your value is, the value of your property is, and you can't sell it for more than that, we're not living in America. This is so unconstitutional in so many ways, it's laughable. And I'm not an attorney, don't even pretend to be an attorney, but this reeks of unconstitutionality and a complete waste of our time. So I'm assuming Senator Wayne's going to pull the amendment, but I remember listening to this in committee and could not believe my ears. This is crazy. Thank you, Mr. President.
Seeing no one left in the queue, Senator Wayne, you're welcome to close.
Thank you, Mr. President. So there's a little bit we should know about constitutional law. Anything we pass here is constitutional until a court proves otherwise, just so we know. But in the committee, Senator Jacobson he did a roundabout face right here. Clearly the floor has changed him. He didn't say it was unconstitutional. That's a whole new concept here he just brought out today. He loved it in committee. Mr. President, I'll pull this amendment. Thank you.
So ordered without objection. See no one in the queue. Senator Halloran, you are recognized to close on AM 2594. Senator Halloran waves close. Colleagues, the question before the body is the adoption of AM 2594. All those in favor vote aye. All those opposed, nay. Mr. Clerk, please record.
38 ayes, no nays, Mr. President, on adoption of the committee amendment.
The amendment is adopted. Returning to the queue, Senator Wayne, you are recognized.
Thank you. I just couldn't hold my laughs when Senator Jacobson was talking, so I had to regroup. But it is a serious issue in Omaha. It is, the problem is I don't know how to solve it, just being very blunt. And so I'm hoping that this body, those who will be here the next few years, will figure out a way, if there is a way, to solve this issue of outside agencies, just like foreign investors on ag land who are arbitrarily causing the costs to go up and prices to go up. So I think we should deal with this. But what I forgot to mention in my amendment is, if you guys vote for my amendment, I know it's off the board, but I'll put it back up there. I'll fix it from general to select file. I'll work on it. Me and Jacobson will get an agreement. So go ahead and vote for AM, whatever that was, 2830. And thank you, Mr. President. That was my closing that we've already missed. Thank you, Mr. President.
Colleagues, the question before the body is the advancement of, excuse me, Mr. Clerk, for a couple items.
Thank you, Mr. President. Senator Kay, I have FA 203 and 204, both with notes you wish to withdraw. In that case, Mr. President.
So ordered.
In that case, Mr. President, I have nothing further on the bill.
Question before the body is the advancement of LB 1301 to ENR initial. All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
39 ayes, no nays, Mr. President, on advancement of the bill.
LB 1301 advances. Mr. Clerk, next item.
Mr. President, Legislative Bill 1368, introduced by Senator Ibach. This bill for an act relating to fertilizer adopts the Nitrogen Reduction Incentive Act. Bill was read for the first time on January 17th of this year and referred to the Agriculture Committee. That committee placed the bill on general file. There are no committee amendments. There are additional amendments, Mr. President.
Senator Ibach, you're welcome to open on LB 1368.
Thank you, Mr. Chairman, and good evening, colleagues. It's fitting that during National Agriculture Week, I present and ask for your support for my priority bill, LB 1368. Before I get into what the bill does, I want to thank the members of the Ag Committee for supporting this bill and the governor for his input on this issue. I also want to thank my co-sponsors, Senators Bostar, Conrad, Dorn, Halloran, Hardin, Holtcroft, Jacobson, Kauth, Myers, Merman, and Sanders. This bill was born from an interim planning committee session that focused on water, specifically nitrates. And I want to thank Senator DeBoer for scheduling very timely and very relevant topics for our committee hearing last interim. But the result of that water hearing mainly focused on reactive approaches, including management of nitrates harmful in our aquatic ecosystem. LB 1368 is a proactive approach to help create awareness of sustainable technologies that increase yields while reducing fertilizer use, reducing costs, and having less impact on our environment. Governor Pillen often says, agriculture is the heartbeat of Nebraska, and I completely agree. LB 1368 encourages farmers to adopt efficient and sustainable practices that help Nebraska protect its natural resources. It positions our farmers to compete globally. LB 1368 is also designed to position Nebraska to win the race to adopt new, innovative farming practices, including, but not limited to, the proper use of biological nitrogen products. Here's what the bill does on a very basic level. The Nebraska Department of Natural Resources, in partnership with the natural resource districts, would develop an incentive program. This program would incentivize farmers to reduce the use of commercial fertilizer and incorporate innovative new technologies. The program will provide an annual per-acre incentive for farmers who, one, verify that commercial fertilizer rates were replaced by the lesser of either 15% or 40 pounds per acre of nitrogen, two, use a qualifying product in their nutrient plans, and three, show a historic baseline of fertilizer use to demonstrate nitrogen has been reduced. All these markers must be qualified through documentation of rates, types of products used, and a history of reductions. In consultation with farmers and industry leaders, a per-acre payment rate tied to the commercial rate reduction, which is one that is not less than $10 per acre, will be established by the NDNR. The department will also be charged with reviewing the rates based on inflation or emerging technology during reviewing years, and we are asking the Department of Natural Resources to assist us in identifying those geographically beneficial target areas while keeping the program open to all farmers across the state. LB 1368 was originally drafted to request $5 million in general funds to carry out this incentive program. After several conversations with stakeholders, I filed AM 3002 that will take the $5 million from the cash reserve fund instead and would harmonize the bill language with the trailing A bill. I would also like to note the bill includes a sunset date of December 31st, 2029, and that will give future legislatures the chance to review the effectiveness of the program. And realistically, I think these biologic products will become so typical in our marketplace that hopefully the markets will drive that change. LB 1368 isn't just about protecting and enhancing our natural resources, which is paramount. It also is about retention to ensure our good life, remains for the next generation. As I reached out to leaders in agriculture about the concepts in this bill, we discussed some of these new and impressive applications available to grow the sustainable ag industry. The message this bill sends is as important as the actual details of the bill itself. This is the start of an even bigger and more exciting discussion involving sustainable agriculture and positioning Nebraska. I want to work with this body and with the governor on how we take this initiative to the next level. As I mentioned earlier, I have an amendment that would change the funding from general funds to cash reserve. But as I look for ways to take this project to the next level, I believe we should look at other sources of funding as well, including water sustainability funds, the Resilient Soils and Water Quality Act Fund, checkoff dollars, and even the Environmental Trust Fund, or a combination of these. Addressing water quality must be a top priority for this legislative body. John Doggett, the former CEO of the National Corn Growers Association, in an op-ed explained what these biologic products do. He stated, "Biological fertilizers use microbes to take nitrogen from the air and nourish the plant all season long. These products actively work to build soil health as they feed the plants without the negative water or air quality impacts of synthetic fertilizers." He closed his letter by stating, "The thin margins inherent to agriculture mean that new technologies come with risk. But when you take a full accounting of the cost of dated technologies, it's clear that the impact on the profitability, the predictability, the safety, and the sustainability deserve more attention, and it's time to support new technologies that offer a better solution." This bill represents an investment in agriculture and an investment in Nebraska's future as a global leader. I believe LB 1368 can have a profound impact on not only the quality of our land and water in Nebraska, but also on its value. Incentivizing the adoption of new sustainable technologies is key to getting ahead of impending threats to production practices and allowing our farmers to lead the way. By working together, we can be proactive and our farmers can be in the driver's seat on this important issue. I also want to note that LB 1368 had great support from a wide range of commodity groups, as well as the Chamber of Commerce, the National Association of Resource Districts, along with the Nebraska Farmers Union, our Exarb and Full Value Agriculture, and the League of Women Voters in Nebraska. I would like to thank you for your attention to this. Thank you for your consideration. And I very humbly ask for your support of LB 1368 and AM 3002, which will become the bill. Thank you, Mr. President.
Mr. Clerk, for an amendment.
Thank you, Mr. President. Senator Ibach of AM 2882, but I note that you withdraw.
So ordered.
In that case, Mr. President, Senator Ibach would offer AM 3002.
Senator Ibach, you're welcome to open.
Thank you. And 3002 just becomes the bill. It's the underlying bill is 1368, but with the amendment of moving the funding from general funds to cash reserve, that the bill becomes 3002. I would ask for your support. Thank you.
Senator Raybold, you are recognized to speak.
Thank you, Mr. President, and I want to thank Senator Ibach for introducing this. You know, she spoke very clearly, and we're all very aware of our water quality in our state of Nebraska. It's imperative that we take these type of proactive steps. But in addition to that, we need to take way more steps. And unfortunately, I think we are way behind the time on making sure that the communities all across our state of Nebraska have clean, safe drinking water. Last week, I sent you all an email from the Natural Resource Office showing exactly $1.3 billion of requests of aging infrastructure, water contamination issues all throughout our state of Nebraska. And these projects aren't cheap. They're $30 million a pop, $5 million to correct. And It's scary. This is in 2023, $1.3 billion of requests from communities all across our state to make sure that we provide safe, clean drinking water to our communities. It's imperative, it's essential, and it's urgent. I have the 2022 report, and it showed $1 billion worth of requests. We can't keep up with the existing revolving fund to help these communities tackle this very urgent problem. In the 2022 numbers, it showed almost 400 million were directly related to nitrate and phosphate contaminations in so many communities throughout our state, not only the ground wells, but other areas of runoff. This is an urgent issue facing our agriculture industry that I'm glad that Senator Ibach introduced us, but we need to be more proactive on other steps. You know, I come from farming families, and I never understood why anyone would want to over-fertilize and any part of their area, because to me, that's just a waste of money. But I know, having talked to enough farmers, they're stubborn. This is the way I've always done it. This is the way I know how to get the best yields possible. And I think steps like this are the way to really educate and create that urgency and that incentive for people to look at different ways of growing the breadbasket of our world. We have to be smarter. We have to come up with these sustainable efforts. It should be regenerative farming. People should be embracing all these new best practices that are going on that preserve and protect our soil so that it has the nutrients and has the productivity to continue to deliver for generation after generation. So this is just one small step, and I wish we could really offer a tremendous amount of assistance to those communities that are struggling right now with the contamination that they're facing, with antiquated water systems that cannot keep up with trying to purify, or the reverse osmosis equipment that ultimately fails after its performance and its operation. So I want to say I do support this. I want to thank the Ag Committee. I want to thank Senator Ibach for bringing it forward. We need to do more.
Senator Erdman, you are recognized to speak.
Thank you. Thank you, Mr. President. Good evening. So I just looked at the fiscal note, and it said it was going to be $5 million out of general funds, and I think I heard Senator Ibach say she wanted to change that to cash reserve. Is that correct? Will you yield to the question?
Senator Ibach, will you yield?
Yes, I will.
Senator Ibach, did you say this amendment 3002 changes it to cash fund?
Yes, that's correct.
I don't know. I guess I should say I'm quite confident that I don't think that's going to work, $5 million out of the cash fund. But as I read through that, it said the incentive is not more than $10 an acre. Can you describe or define what that means?
Well, the incentive for $10 per acre would be for those that choose to use the biologic products or other technology advances. They would be rewarded or awarded $10 per acre. Right now, if you look at the cost between an anhydrous fertilizer and a biologic, $10 seems to be about the gauge as far as cost differential. And so by incenting farmers to invest or at least try the biologics approach, then we are incenting them to use those products in a cost-effective manner. When corn is $7 an acre or $7 a bushel, it becomes a lot more enticing for farmers to try new methods. But when it's down at the $4 level, which it is now, I think farmers are a lot reluctant to take that risk.
Okay, so let me see if I'm understanding. Are you saying that $10 an acre will buy that much anhydrous ammonia would buy the other fertilizer? Is that what you're saying? About the same amount, send $10?
That's correct. So for 40 pounds of a biologic, it's about $25 to $30 an acre. And if you're putting on like we do, like 3200, I mean, you're looking at the $15 to $20 an acre, depending on when you buy it.
Right.
So we prepay ours in the fall. And so that's a cost differential.
Okay. So it says not less than 10, so it could be significantly more than 10? It could go up from there?
I would propose the $10 per acre.
That's not what it says. It says up not less than 10.
Yes, and I would rely on the department to help us come up with that amount, but my recommendation will be $10.
So your recommendation would be something you suggest, but if you don't put it in statute, then the department can do whatever they would like, greater than $10. Would that be the statement? That be a true statement?
I would be happy to, between general and select, to fix that.
I think your issue is where you're going to get the money. Okay, I understand the concept. I understand what you're trying to do. We, the state of Nebraska, established NRDs 52 years ago, and part of the charge or part of their MO was to deal with the nitrates. And I would say most have done a poor job of actually doing anything to reduce nitrate contamination. And so I think incentivizing the farmer makes more sense than giving it the NRDs, but I'm just concerned about where we're going to get the $5 million. Thank you.
And I can appreciate that too, which is why my staff has kind of looked at other sources of funding. And so a lot of people have said 5 million doesn't get us started, but I think this will get the program underway and get us started. And then we can always look for other sources of funding as well.
Senator Jacobson, you are recognized to speak.
Thank you, Mr. President. I really didn't intend to speak on this, but then I started hearing all the stuff about farmers not taking care of the land and we got to do more and all this. And I don't mean to pick on Senator Raybould, although I would invite her to certainly come out and visit a modern farm today and see how that works. And so for those that are listening, I just want to make sure I can't let it slide that those things get said and you're all thinking that farmers are out there dumping all kinds of nitrogen on their soil indiscriminately and phosphate, and it's just not reality, okay? The nitrate problem we have today is the sins of those back in the 50s and 60s, where there was over-fertilization because anhydrous ammonia at that point in time was dirt cheap. People were putting on more because you were seeing higher yields. They didn't really know to what degree they could put more fertilizer on and get higher yields. The research that's been done since that time has been overwhelming. And I will tell you that the nitrates that went on back in those days are moving down. They're well below the root zone. And so that nitrogen is going to continue to move down and it's going to go into the water table. And so no matter what you do today, you could quit putting on nitrogen fertilizer on every acre and you will still see the nitrate problem there because it's already in the soil. I would also argue when you go to cities, look at somebody's lawn and look at the rate of nitrogen you put on your lawn, and I will guarantee you it's at a higher rate and you get more leaching into the groundwater in towns than you do out in the country. If you think about what farmers do today, these farms work like gardens, and that's one reason why we need broadband at the speeds that we need today with fiber. Because farmers have tractors that have the technology to where they're using GPS, and you've got planters that literally don't overplant. They get to the end of the field, they know where you'd already planted, and it shuts the individual row units off. You have the ability to use sprayers, including fertilizer applicators, where they go out and they test all over their field, put it into a program, into a map, and the fertilizer applicator literally goes across the field and only puts on the specific amount of fertilizer needed for that particular part of the field. That's how scripted it is. I can assure you that farmers are not indiscriminately doing things that are harming the soil. They're also planting cover crops in the fall. They're planting cover crops because they know what the microorganisms, keeping them working in the wintertime, allows for that soil to be mellower. It also keeps from being blowing and from erosion. It's amazing what's going on out there today. Truly amazing. And so I just want everyone to know that with this bill, the reason I support the bill is you have those leading edge farmers that are already using biologics, like Senator Ibaugh has mentioned. And then you have those producers who are not early adopters. And this incentive program is going to get those not so early adopters to try it. And once they do, they're going to see the benefits. And then whether there's an incentive or not, they're going to continue to use them. That's the value of this bill. That's the value of this program. I'm also going to tell you I'm a big believer in NRDs. Where my farms are at, we're located in the upper Big Blue NRD. We have high nitrates. I can guarantee you they're managing that. They're managing what we can do in terms of fall fertility. They're managing what they're doing there. I believe the NRDs have done a great job. I support what they're doing, and I think they continue to get better and better in terms of looking at the quality and the quantity of water. So with that said, I support the bill. I think it's a start, and I think what it will do is it will get people engaged, and I think it'll take care of itself. We won't be needing to put big funding in it in the future because I think we'll get the later adopters to adopt. Thank you, Mr. President.
Senator Clements, you are recognized to speak.
Thank you, Mr. President. Well, I also have a concern about the cash reserve expense where we are right now at our target level of the cash reserve. But we have had some large expenses in the past. Had the Perkins Canal estimated at $560 million. But as time goes on, costs go on, the investment earnings on that is going out elsewhere, not adding to that fund, which would have helped with inflation. But I think this likely will have more expense from the Perkins Canal project. The new prison is over a year or two away. The $360 million there, a 10% increase is $36 million. I think it's a interesting program, but the $5 million I think would just be a start, and having a state fund it with its cash reserves is questionable to me. I think I would support it. If we could find another funding source, I would urge Senator Ibaugh to look for other ways to fund this, and maybe more that are ag-related to where the people receiving the benefit are agriculture people rather than just everybody else in Nebraska, although it is going to hopefully help the nitrate situation. But I agree with Senator Jacobson that problem was created a long time ago. The town where I live, the town wells have nitrate above the limit. We have a reverse osmosis system in the city, so we've been doing that maybe 20 years already. So I am going to have to withhold my approval until we find out what the funding is. The other concept with progressive innovation in agriculture is good to look into, and so I look forward to this bill. I probably will just be not voting and observe it as it goes along, and hopefully we can look for other funding sources. Thank you, Mr. President.
Senator Wayne, you are recognized.
NRIA. Thank you, Mr. President. Will Senator Ibaugh yield to a question?
Senator Ibaugh, will you yield?
Yes, I will.
This is called the Nitrate Reduction Incentive Act.
That's correct.
How do you say that? NAR? NAR?
I haven't given it an acronym yet, sorry.
Okay. So no, a serious question. This applies to farmers, to rural. Did you hear that, Senator Jacobson? This is $10 million going to $5 million going to rural. Is that correct? 5 million? Okay. So I have
Not to housing, but to, yes,
Right.
to rural.
So I have a proposal for you, so we'll see if you accept it. Can we split this between urban and rural? So 2.5 can go to homeowners in the urban, and I'm being serious here now, because we water our lawn and we put nitrogen on our lawn, and we should be incentivized to do better too.
Well, I'm glad you admitted that, because that is a true statement. However, I think we need to wait until the residential lawn nitrogen biologics program is secure before we start throwing money at it.
How would I secure it? I can start with my lawn.
So I think there are biologic companies out there that are working on identifying the microbes that would work on residential and golf courses. And I think that's probably in the very near future. But from my experience right now, I don't know that those are available. But I would be willing in the future, if they become available, to speak to your request.
Okay. So you'll work with me on this next year?
Absolutely.
Okay.
Next year.
Thank you. I appreciate you taking time and committing to working with me on this resolution next year for the urban farmers. Thank you.
Thank you, Senator Wayne and Senator Ibach. Senator Raybold, you are recognized to speak.
Thank you, Mr. President. I just didn't want Senator Jacobson to get away with creating an impression that I think our farmers aren't doing their jobs and don't take care of our precious land. And I do accept his invitation to go out and visit farms, but I got to tell you, I have been so fortunate to have visited many farms and ranches already and have seen such innovative practices going on using technology to make sure that they don't over-irrigate and that they don't over-fertilize. So there is hope out there. I wanted to say there's hope, and our farmers and our agriculture committee is trying to do everything they can. Unfortunately, Senator Jacobson is right. This type of nitrate and phosphate contamination is going to continue until we are better. The data shows that there's more and more contamination, and that's why steps like this are so important. That's like all the innovative ideas that are coming out of the University of Nebraska and other think tanks are ones that we should be doing. But I'm still happy to go visit many more farms and ranch, and I do appreciate our agriculture committee.
Thank you, Senator Raybold. Senator Erdman, you are recognized to speak.
Thank you, Mr. President. Off the mic, I had a conversation with Senator Ibach, and I made a suggestion that perhaps she could find some funding through the NRDs. It would seem to make sense to me that what she's attempting to do here is one of the things that we've charged the NRDs with is that controlling nitrates or reducing nitrate contamination. And so, Senator Ibach, I would suggest that you contact the NRDs and say, hey, this is the program that I've decided we needed to do. And I believe that they would understand the significance of what it is you're attempting to do. They have a relationship with the farmers already. And who better to promote a program like this to farmers but somebody who already has a relationship with them. And so they may have, if you got some money from them, it may make it a lot easier to find the rest of the money to do this. And if you find that it works, the money will be a lot easier to get. And by the way, Senator Wayne is not going to work with you next year because Senator Wayne is not going to be here next year. Now, if he is, I'll be totally surprised. But I think my comments about the NRD are worth checking into. Thank you.
Thank you, Senator Erdman. See no one else in the queue. Senator Ibach, you're recognized to close on AM 3002.
Thank you very much, Mr. Chairman. And to Senator Erdman's point, the NRDs did come and testify in favor of this bill. And so I will certainly reach out to them for their support. I'd also like to thank everyone for the great discussion tonight. And again, I believe that incentives encourage change. Where would we be in the ethanol industry if we didn't encourage incentives? And I really do believe that this change will address some of our water quality issues and definitely promote our sustainability efforts that we make every day. So thank you. I will appreciate your green vote. Thank you, Mr. Chairman.
Thank you, Senator Ibach. Senators, motion before the body, the adoption of AM 3002. All in favor, vote aye. All opposed, vote nay. Have all voted who chose to? Record, Mr. Clerk.
34 ayes, no nays on adoption of the amendment, Mr. President.
See no lights, the amendment is adopted. Senator Ibach, you can close on LB 1368.
As I mentioned, this is the underlying bill. I appreciate your support for it. Thank you.
The question before the body is the advancement of LB 1368. All those in favor vote aye. All those opposed vote nay. Have all voted who chose to? Record, Mr. Clerk.
35 ayes, no nays on advancement of the bill, Mr. President.
LB 1368 is advanced. Next bill, Mr. Clerk.
Mr. President, Legislative Bill 126, introduced by Senator Day. It's a bill for an act relating to revenue and taxation, changes provisions relating to homestead exemptions for certain disabled veterans and surviving spouses as prescribed, harmonizes provisions and repeals the original section. Bill was read for the first time on January 6th of last year and referred to the Revenue Committee. That committee placed the bill on general file with committee amendments, Mr. President.
Senator Day, you're welcome to open on LB 126.
Thank you, Mr. President. Good evening, colleagues. LB 126 creates a straightforward way to extend our state's homestead exemption to veterans who are partially disabled while serving our country. At the moment, Nebraska only provides a homestead exemption for disabled veterans who have a 100% service-connected disability. Currently, Nebraska offers homestead exemptions to the following categories: persons over age 65, veterans totally disabled by a non-service connected accident or illness, qualified disabled individuals, qualified totally disabled veterans and their surviving spouses, veterans whose home was substantially contributed to by the VA and their surviving spouses, or individuals who have a developmental disability. Given the challenges that disabled veterans face, LB 126 is consistent with Nebraska's existing homestead exemption categories, and an exemption for partial service-related disabilities has already been implemented in other states, including Alaska, Illinois, Kansas, and Vermont. As many of you may recall, this bill is an update of legislation that I brought in 2022, LB 853, which reached select file with no opposition in the final days of session, but we ran out of time and fiscal flexibility and the bill died. In the original version of the bill this biennium, LB 126 provided a flat amount of relief based on the disability rating of the veteran. So 90% disabled was $900, 70% was $700, and so on, which was an attempt to limit the bill's fiscal note. Under the amended version of the bill, it would provide a relief for anyone with a 50% to 90% disability rating, and your amount of homestead exemption would be based on your income level. You can see the breakdown if you look at the tables on pages 10 through 12 of AM 2941. I will let Senator Linehan explain the changes to the broader homestead exemption with the amendment, but this is how the relief would be given for disabled veterans under the amendment version of the bill compared to the original one. When discussing the rating system for partial disabilities under the VA rating system, there's a number of misconceptions, the biggest being that these aren't major injuries. While these are partial disabilities under the VA's rating system, to most of us, these would be considered life-altering disabilities. For example, a case of 70% impairment for post-traumatic stress disorder involves suicidal thoughts, near constant panic attacks, inability to manage stressful situations, and a projected 70% loss of earnings. To take another example, most arm amputations, unless they're done all the way to the shoulder, are below 90% and considered partial disabilities. Multiple finger amputations is a 60 to 70% rating, and toe amputations are a 20 to 30% rating, depending on which toe is amputated. So there's a divergence between the true severity of these disabilities and the rating system. Especially in the 50 to 90% range, these are major and significantly life-changing injuries. Although it can often be lost when we're staring at percentages and injury descriptions on a table, I would urge everyone in this room to consider the life-altering changes that those with service injuries go through, and consider the physical and psychological loss as if they suddenly happen to ourselves or a loved one. For roughly 40,000 Nebraska veterans who have a service-related injury, this is their daily reality. A life forever altered by the courage they showed in serving our country and our way of life. I'm not going to pretend that this is anywhere near what veterans have sacrificed to defend us and our way of life, but it is an attempt to make things just a little bit easier for those who have done so much for us. So it's my hope that we can provide targeted property tax relief to those who have made these life-changing sacrifices to us. And please vote green on LB 126. Thank you, Mr. President.
Senator Linehan, you're welcome to open on the committee amendment.
Thank you, Mr. President, and good evening, colleagues. And thank you, Senator Day. I really appreciate what she's done here. She had a bill that she brought last year, I believe it was last year. Yes, by the number, you know it's last year, 126. And she worked hard on it. She had a great hearing with several veterans, including one that's from my hometown where I went to high school. But this year, what happened is we had bills from Senator Doe in front of our committee on the Homestead Act. Senator Dover had a bill, Senator McKinney had a bill, Senator McDonald, Senator Jacobson, Senator Frederickson. So clearly, this is an issue that several members have heard about and know, and we all know that we're having a problem with people being able to stay in their home because of property taxes. So what the committee did is we tried to take what we thought was the best part of each bill, including Senator Day's bill, and then tried to shape it in a way that we could help more people, but also do it in a fiscally responsible way. So some of you already asked me about the fiscal note that's attached to this bill. That fiscal note is Senator Day's fiscal note from last year, because we don't get a new fiscal note on an amendment until we pass it on general. So this is what, and I'm going to be trying quick here, and I also want to say there is no doubt in my mind that when we get it back from fiscal, we'll have to make adjustments. Maybe we can do more, maybe we can do less, but we're going to ask for the sky here and see what we get. AM 2941 allows anyone, and this is very important because you'll get questions on this, allows anyone currently under the homestead exemption law that is enforced today to either choose to stay on that or to apply to the new exemption. So everybody who's got a homestead exemption today, if they still qualify, because people are getting knocked off homestead when their valuations go up. But if they're on that program's working for them, if we pass the new homestead one, they'll be grandfathered into the old system. AM 2941 also establishes a new system of payment under the homestead exemption where everyone is required to pay some amount of property taxes, starting at the minimum of $100 per month. And our thought process was on that if you're staying in your house, You're paying insurance, you're paying utilities, the police still have to come by, the fire department still has you there, so you should pay something. So the least you would pay is $100 a month. Right now, at certain levels, I think 37,000, you don't pay anything. AM 2941 also further establishes a $1 million total asset cap on qualifying for the homestead exemption for married or single persons. So in other words, if you have over $1 million in assets, you're not going to qualify for the new homestead exemption. A trade-off for that, it doesn't matter, well, obviously if your house is over $1 million, you're going to get knocked off, but we're not going to that thing where you have to worry about your valuation going up. As long as your assets are under $1 million, the value of your house is irrelevant. So you can have $1 million in assets. And also, this was from Senator McKinney, for those in a qualified census tract, the amendment establishes a new homeowner entitled to a 50% valuation reduction for their first 5 years. Senator Kinney brought that bill, and part of that is I talked, or maybe I was writing it for a press release I'm doing for tomorrow, but part of the problem we have in Omaha, and I'm sure Lincoln, other places, is we have groups like Habitat Humanity who fix up a house or build a new house, actually get a family established in a home, and then the valuations come along and kick them out of the home. So give them a few years to get established before that valuation starts rising. AM 2941 established a qualification for homestead exemption for the elderly, that also that you must have started drawing on Social Security or equivalent retirement system like railroad or civil service retirement. In other words, you're not going to be qualified for homestead exemption just because you turned 65, because many of us are 65 and still working, so you actually have to be retired. That is part of trying to save money on the program for the people that can still work and still pay the property taxes, and it's also to encourage people to stay in the workforce. The amendment also establishes parameters for homestead exemption for disabled veterans. This goes back to Senator Day's priority bill that is this amendment is going into, that they must be classified as at least 50%. So today, as Senator Day said, it's 100%. Now they will qualify at 50%. So I have a chart here. I'm not going to bore you, but it basically anything under 40,000 income, and that's AGI. So as we know, that'd be after exemptions. That's $100 a month. 40,000 would be 110 a month. 45,000, 150. So it goes up as your income goes up. We also, and if it's not in the bill, we meant to put it in, there's also a clawback provision like there is for Medicaid. So if you can't wake up one morning, give all your assets away and then qualify for the homestead exemption the next day, which I have been told has happened. Well, I've actually told people, I've had people tell me they did that. So there'll be a clawback provision. And finally, I think this is finally, somebody else on the Revenue Committee, if I'm forgetting something, please punch in and help me. The amendment includes language and a provision from LB 1151 introduced by Senator Dover, adding a definition of occupy within the homestead exemption status. What happens now, and Senator Dover, if he would like, could speak to this more specifically, but you move your mother or your grandmother into nursing home, and she's telling you and you're promising you can go back home, Mom. This is just for a little time. This is to recover. And maybe that's not likely, but the minute you're forced to give up that homestead exemption and you're therefore, as a family, forced to sell that home, that person in the home is not going to last very long. And it's a bad situation, and we shouldn't, so we need to qualify that, because in some counties, it might be 6 months, in other counties, it goes 2 or 3 years. So we need to bring those closer together. So I hope that covers it. Again, pass this tonight, we'll get a fiscal note, we'll have to sit down and look at it and see what we can do. But the big picture here was, this is help as many as we can, but let's skinny down the help so we can help more people and make sure that there's not abuse of the system. Thank you, Mr. President.
Senator Jacobson, you are recognized to speak.
Thank you, Mr. President. First, let me say I appreciate all the work of the Revenue Committee. I know they've had a lot of things on their plate, and there were a lot of bills to look at. And certainly when you get that many homestead exemption bills, it's a big load. I do have some concerns. Probably the first thing I look at is I like Senator Day's base bill. And if we get nothing else done and just adopted her base bill and left everything else the same, I'd be okay. I do like a lot of the enhancements. I know Senator Dover is going to speak to the situation of the intent to occupy the house. I do like the fact that you need to be retired. Just because you're retired, we need to keep people in the workforce. So I like that change, and I don't have any issues with the total asset limit. But we've run the analysis in North Platte, for example, and in Lincoln County, where the average home value is $141,000 and the average household income $61,000. And I will tell you, if we adopt the bill the way it is, there will be more people losing their homestead exemption than benefiting from it. The good news is we'll get veterans that are 50% disabled covered, and that's a high priority for me. But we're going to create a lot of damage on the other side. I think when you start looking at all of the disparity across the state in terms of household income and average values and tax rates, it creates some problems. So from my standpoint, I would like to see some changes made to the bill. I do intend to vote for the bill to get it to select, but I can't support the bill in its current form because it just doesn't work for too many of my constituents, and I think constituents across rural Nebraska are going to end up losing their exemption. Some other thoughts might look at, I think, those that I've got one example I gave in when I introduced my bill. A lady who's now lost her husband in 2017. She's retired. She lives in a home that's on Lake Maloney, south of North Platte. It's a leasehold improvement. It's owned by MPPD. It's a 1 acre lot that's on the water. She and her husband lived there for decades. The home and the single car detached garage is tax assessed at $82,500. But the land underneath it was tax assessed at $350,000 this past year. So she no longer has a homestead exemption. Qualifies on income and has qualified historically, but over the last few years, these lake properties, this land has just gone through the roof. So now she's going to be forced to sell her house because she can't afford to live there. These are the people I thought we were trying to help with the homestead exemption. And this doesn't work for her. And if we look at, you had to have the homestead exemption existing, well, she lost it a year ago. In fact, I think she lost most of it 2 years ago. So unless we have at least a 3-year look back and say if you qualified over that time frame, she and many other people are going to be out because of what's happened to escalation of values over the last few years. Keep in mind also when you go into rural areas, you've got a lot of farm homes that are older homes that don't tax assess very high, and it brings your average value down. So if you're living in one of the cities, you're going to find that the averages are too low.
1 minute.
So those are some concerns that I have with the bill. I'm hopeful that I can work with Senator Linehan and the committee to make some changes to that. Otherwise, I would hope that we would just amend the bill to allow for Senator Day's bill to go in its entirety and not make any other changes and potentially do some interim study in the meantime to come up with something that's a little more equitable for all areas in the state. Thank you, Mr. President.
Senator McKinney, you're recognized to speak.
Thank you, Mr. President. I rise in support of AM 2941 and LB 126. I brought a bill, I believe, LB 924, to provide a homestead exemption for individuals in qualified census tracts. I brought that bill because over the interim, I got invited to have a conversation with some seniors in my district at Catholic Charities. And during that conversation, a few of the seniors in my district brought up the homestead exemption, and they brought up how it really didn't work for them, although they were seniors, it just didn't work for them. So I was like, well, I'll at least try to bring a bill to address it a little bit. And I brought my bill to try to provide a homestead exemption for individuals in qualified census tracts. And I'm happy to see some provisions in this amendment, and hopefully we get this passed, that it does something. And everything else in here, I'm good with as well, because I think we as a body should do all we can to try to assist our seniors that are retiring and also those that have served our country. I think that's important, especially with rising property taxes, rising housing costs, and those type of things. And that's what was brought up in that conversation. They were like, we're on fixed income. My property taxes are rising. I'm on a fixed income. I don't really qualify for the homestead exemption, but I don't make a lot of money. Can you, Senator McKinney, try to do something about it? And that's why I brought the bill to provide a homestead exemption for individuals in qualified census tracts. So I was happy to see this added to the amendment. And I hope that everybody can support this all the way through, because I think this amendment and this bill serves not only my district, not only Senator Day's district, but I think it serves individuals across the state. So I hope that everybody will see the value in this, especially for our seniors and those who have served our country, because I think it's very important to do what we can to honor them and provide any type of help that we could to, at least once they retire, some type of comfort in those retirement years. So thank you, and I'll yield the rest of my time to Senator Day if she would like.
Senator Day, you're recognized. 2 minutes, 14.
Thank you, Mr. President, and thank you, Senator McKinney. That is helpful. I did want to mention, I appreciate Senator Jacobson's remarks. He and I have discussed it briefly. I did have some questions about the amendment, particularly the issue that he mentioned with the $1,200 minimum. And so I think first, when the amendment was given to us after the bill was moved out of committee, we did go talk to AARP because we figured they would have the best ability to analyze any potential benefits to seniors or any potential drawbacks to seniors on this particular piece of legislation. And they assured us twice that from their analysis of the amendment, that seniors will be better off overall, even with the $1,200 minimum. So I did want to mention that, although I will say going forward, I am flexible with that if that's a sticking point for several people. Again, I would like to move this to select so we can get a fiscal note on it and see what that looks like and what we need to move around to make improvements. Thank you, Mr. President, to make improvements to the bill. And to get everybody on the same page with being able to support this. So I will yield the rest of my time to the chair. Thank you.
Senator Dorn, you're recognized.
Thank you, Mr. Speaker. Echo a lot of some of the comments that have been made. I've been hearing about from different senators that there were going to be some amendments or some, I call it, putting some bills together to come up with a program, hopefully a revised program, I call it, on the homestead exemption. In the green book that everybody got, the Appropriations Committee proposal, part of what's gone on in the last few years is because as valuations have gone up, and that's part of our property tax discussion, as valuations have gone up, it has also put the homestead exemption that has increased. This last year, right now, this year, we did increase in the budget a little over $14 million. And currently, per 2024 session, the homestead exemptions are listed at in our budget, 142 million, just over a little over 142 million. Next year to be 149 million. So I'm very, very thankful that the committee, a lot of people did a lot of work at looking at this process and seeing what we can maybe, I call it, making sure the program is working the way it was intended to work, so that we don't have some people heard some stories about $300,000 house and didn't pay any property taxes because they were homestead exempt. I don't think that's the purpose of the program. The purpose of the program is to help those that need the help, our elderly people, our disabled veterans, or other people like that that need the help to pay their property taxes so that they can stay in that property or whatever. So very, very glad that they did a lot of work on this. I too would like to see very much the fiscal note. I looked at the fiscal note on Senator Day's original bill. It had 19 million. Well, at that time, we were paying about 120 million total in homestead exemptions. That meant 1/6 of them were now going to be brand new disabled veterans. I really, really question that if 1/6 of the people on the homestead exemption were going to be now new people that were so-called disabled veterans. I'm not questioning the 20 million, but I don't think we have that much of a percentage wise of that population that would bring it up to be 1/6 of that dollar amount. No, so that's why really excited or really waiting forward on this bill here to see after we hopefully pass this on general and get it to select so that we can see another fiscal note and see what that how that plays into our budget and all those things. So I will be supporting 2941 and 126 as we vote on them tonight here. Be interested as we have our discussion on select. Thank you. Yield my time.
Senator Meyer, you're recognized.
Thank you, Mr. Chairman. I rise in support of both LB 126 and AM 2941. I think, and I'm new at this, but I have quite a bit of experience with the homestead exemption program. My wife's been a real estate broker for 45 years. Last week, she sold a house for $300,000 to a lady who was widowed. She was moving into her mother's $500,000 house and taking her tax exemption with her. And so my wife checks the real estate records at the courthouse, and yeah, she owned a couple farms besides that. I am 100% in support of homestead exemptions for people that really need it. I will go to bat for those all day long, but I will not for people who somehow go around the program to take advantage of it. And when I hear Senator Dorn's figures, the escalating value of that total for property tax exemptions, it's a little bit scary. I think the amendment are some real common sense approaches to kind of getting a handle on the total that will be involved in this going forward. I think the $1 million cap is very reasonable. Like Chairman Linehan said, you could have a couple shares of Berkshire Hathaway stock who don't pay dividends and you would qualify for homestead exemption. I mean, in what world is that okay? It's just plain not. That means that everybody else has to pay more. For everybody else that cuts a corner someplace, somebody who really struggles to make ends meet but doesn't qualify, say they have a family that has their kids in school, they're struggling to pay their property taxes, that's a problem. So I will support AM 2941 and 126. I want to thank Senator Day for allowing the Revenue Committee to tack this on, but I think there's some long overdue changes that are involved in this amendment. I think the 3-year look back kind of coincides with a Medicaid example, and I think that's necessary because I know that there's legal gyrations that take place in families to get their loved one qualified for homestead exemption and thereby, again, maybe cutting somebody out who should qualify for it who doesn't. So I stand in support of both of those, and I'll yield my time. Thank you.
Senator Vargas, you are recognized.
Thank you very much. I rise in support of the amendment 2941. Thanks, Senator Day, for her work. I'm just going to add a little context from the appropriations side, because whenever we get a chance, and Senator Dorn was alluding to this, he was touching upon this, we balance the budget based off of large expenditures and large exemptions. And one of the things I'm the most proud of from our committee is we make sure that we're balancing the budget, assuming that this is going to continue to grow because we're trying to do more. as Senator Dorn mentioned, the current appropriation for homestead exemption in 24 is 142 million. For FY25, it's 149 million. I say this because it's important to know how much we are budgeting within the appropriations process, setting aside for the homestead exemption. And while it is a very good thing, and I look forward to seeing the final version, it also is a caution in the future for all the bills and the things that we intend to do that have a general fund expenditure. Because two things were the biggest items within our budget. One was TIOSA. Number two was our increased amount we had to go to homestead exemption. We will do as much as we possibly can with the appropriations process to balance around the big rocks. That's our responsibility. We don't always get credit for the revenue things, but I think we're building around those things. So I just want to make sure that's really clear. That's the work of what we do in appropriations. But it also means that every single bill that's a new general fund expenditure on the floor also is future revenue losses or future amounts that are off our budget in the future. And I just want to make sure that's clear. I support this. I support what we're trying to do. And I really do appreciate the committee for looking at the fiscal note in the next round and figuring out how it's all going to work. But it's something that we work around in the Appropriations Committee because it's a good program and we're trying to do that. And with the additional tax relief that we've done the last several years, significant tax relief in different areas, we want to make sure that we're balancing the budget around these big rocks. Thank you for the Appropriations Committee for that work. And I just wanted to make that shout out to our committee.
Mr. Clerk, for an amendment.
Mr. President, Senator Holcroft would move to amend the committee amendments with AM 3133.
Senator Holcroft, you're welcome to open.
Thank you, Mr. President. And colleagues, thank you for the opportunity to discuss AM 3133 to AM 2941. AM 3133 contains the language from my LB 1019. The intent of LB 1019 is to eliminate the need for a county board of equalization to vote on a final order from the Tax Equalization and Review Commission, or TERC, on a taxpayer's valuation appeal. Currently, after a final order has been made on a taxpayer's valuation appeal by TERC, county boards of equalization must hold a hearing wherein the board, by law, must reaffirm the decision of TERC. This current process of having the County Board of Equalization formalize TERC's decisions can be a source of frustration to the appealing taxpayer. The taxpayer may wait weeks for their case to be processed and sent to the County Board of Equalization, hoping their case can be heard by the board, only to find out at the hearing that the board cannot deviate from the TERC's decision. Adopting LB 1019 would eliminate this confusion, clarifying the valuation appeal process for the appealing taxpayer and streamlining the process for the County Board of Equalization. So this was brought to me by actually the Sarpy County Board of Equalization, and it is just to streamline the process. If a taxpayer appeals their valuation to the Board of Equalization and they don't like the result, they can go to the TERC, the state level, and then the state level makes a decision. And by the current statutes, it's then sent back to the Board of Equalization where they have to approve it. This would eliminate that extra step. So this came out of Committee 8-0. Originally was submitted as a consent calendar, but judging by we may not be able to get to that, Senator Linehan has allowed me to amend it to 2941. Thank you, Mr. President.
Senator Clements, you are recognized.
Thank you, Mr. President. I appreciate what Senator Vargas said regarding the budget and the dollars that we already spend on homestead exemption. The base bill showed over $19 million of fiscal note, and we've talked about the fact that there's maybe 23 million max to the floor. I think it's reduced a little bit now. And so that would use all of the money to the floor for A bills. And so I'm hoping that the adjustments in the amendment will bring that down some. I'm going to vote this on to select so we can see what the fiscal note would be with the adjustments, but I don't think we have room for $19-20 million in one A bill. So thank you, Mr. President.
Senator Boson, you are recognized to speak.
Senator Hughes pushed my button.
Oh, I am so sorry.
Senator Erdman, you are recognized to speak.
Homestead exemption.
Thank you, Mr. President. So I just went down and visited with Senator Holcroft about his bill on Turk. So let me just explain that. Senator Wayne had asked me a question. So Senator Dorn, you'll like this one. So what he's trying to say and do is that once Turk makes a decision, the decision comes back to the County Board of Equalization. Then they have to have a hearing and decide and set the price or set the value. And so what Senator Holcroft is trying to do is say once Turk has made a decision, that's the value. So he's trying to cut out one step. So I think that's appropriate until we eliminate Turk, but I think that's a good program, so I'm going to vote for that. Thank you.
Seeing no one in the queue, Senator Holcroft, you're welcome to close. Senator Holcroft waives close. Question before the body is the adoption of AM 3133. All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
40 yeas, no nays on adoption of the amendment, Mr. President.
AM 3133 is adopted. Senator Linehan, you're welcome to close on AM 2941.
I'm just going to, 3 quick things. I repeat, because I've already gotten a couple questions on this, and you will get emails, so have your staff aware that anybody who's on the current system, the current homestead exemption is grandfathered. We're not going to take anybody off the system. This doesn't. And Senator Holcroft already said his amendment was friendly. It's already passed. The other thing, just to echo what Senator, I think, Vargas and Senator Dorn said, when I first became chair of Revenue Committee, the homestead exemption was just under $100 million a year. I had a bill to say that the counties had to pick up anything over $100 million. They came in clearly against it because they could see what was going to happen. So that's in 5 years, it's grown that much. So it's an issue we're going to have to address. I appreciate your support on this amendment, and again want to express our great appreciation to Senator Day for letting us use her bill and her priority to help get a lot bigger project done. Hopefully, thank you.
Question before the body is the adoption of AM 2941. All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
39 nays, no nays on adoption of the committee amendment, Mr. President.
The amendment is adopted. Senator Day, you're welcome to close on LB 126.
Thank you, Mr. President. I'll keep this brief. This is an issue that I have been working on for years and years and years. It was one of the very first things that I heard about when I was a brand new senator. I had a constituent. I'm sure many of you have probably received emails and phone calls from him. His name is Lance, and he has been following this the whole way. It is something that he has wanted for a long time, and I would love to be able to get this done this year for him and for all of the other partially disabled veterans that deserve this benefit. I also want to make sure that I thank Jim Shuey from Disabled American Vets. He has also been working extremely hard on trying to get to a decent place with the fiscal note on our bill. And obviously we are still continuing to work on that. Hopefully it will be cleaned up a little bit on select file. And lastly, well, not quite lastly, I want to thank my co-sponsors, Senators Aguilar, Conrad, Holdcroft, Brewer, Blood, and Jacobson, who are helping me work on this bill and get it through final reading this year. And especially a huge thank you to Chairwoman Linehan and the entirety of the Revenue Committee and their incredible work on this package, and allowing me to use my priority bill to help work on the homestead exemption as a whole. So thank you. I appreciate your green vote.
Question before the body is the advancement of LB 126. All those in favor vote aye. All those opposed vote nay. Ms. Clerk?
39 ayes, no nays on advancement of the bill, Mr. President.
LB 126 does advance. Next item, Mr. Clerk.
Mr. President, Legislative Bill 1027, introduced by Senator Clements. It's a bill for an act relating to education, changes provisions relating to schools which elect not to meet accreditation or approval requirements, and repeals the original section. Bill was read for the first time on January 5th of this year and referred to the Education Committee. That committee placed the bill on general file with committee amendments. There are additional motions and amendments, Mr. President.
Senator Clements, you're welcome to open.
Thank you, Mr. President. Legislative Bill 1027 revises Section 79-1601, which covers requirements for exempt schools, which include private, parochial, group, and home schools. LB 1027 aims to eliminate some cumbersome barriers for parents or guardians who elect to educate their children in exempt schools. The bill was heard in the Education Committee January 22nd, had 14 proponents, no opponents, and 3 neutral testifiers. LB 1027 is the first major update of the homeschool law since LB 928 was passed in 1984. At that time, the track record for homeschools and church schools was very short, so several oversight provisions were placed in law, but have never been used. Since then, the track record of exempt schools has proven to be very good, and they currently have over 13,000 students enrolled. Currently, both parents are required to sign an election form for their child to attend an exempt school every year. This has caused problems with single-parent households and divorce situations where one parent refuses to sign the annual application. My bill would provide that only one parent or guardian signature is required. This change would align the requirement with that for public school enrollment, where only one parent's signature is required. The bill would replace an annual acknowledgement requirement with an annual assurance statement. The assurance is a signed statement by one parent or guardian that the education provided will comply with the law. My original bill removed the annual notice requirement. During the hearing, NDE, Department of Education, testified neutral and suggested that an annual notification would be their preference. To address these concerns, the annual requirement is retained in the committee amendment AM 2440, which I support. I'm encouraged to hear NDE's plan to streamline the enrollment notification system for the coming year by making it an online form for a parent to update and submit. The bill removes some of the 1984 provisions which have not been used. First, the requirement to offer evidence of teaching competence has never been used and is removed. Second, student achievement testing has also never been used and is being removed. Third, provisions in Section 79-1601 for visitation and inspection of exempt schools have also never been used and are being removed. A separate school superintendent inspection provision in 79-1605 has also never been applied to exempt schools. Amendment AM 3075 would remove its application for exempt schools. I believe it's important to respect the privacy of parents in their choice of educational settings for their children. I was pleased to hear that the department has allowed exempt schools to operate without heavy oversight. NDE testified at the hearing in a neutral capacity with concerns about the annual requirement and some other language regarding administration of exempt schools. I was happy to address those concerns in AM 2440. I'm pleased to report the department is now a proponent of LB 1027 with AM 2440. I provided their letter as a handout to the body. Thank you for your consideration of LB 1027. Thank you, Mr. President.
Senator Merman, you're recognized to open on the committee amendment.
It just adds the annual requirement.
I'll yield on the committee amendment to Senator Clements.
Senator Clements, 9 minutes 40.
The committee amendment keeps the original bill intact, except that it does, the original bill said that a parent could only had to report one time that they were going to be exempt, or if their student changed schools, they would have to report, but not every year if they were still in the same school. So, but the department requested an annual notification and assurance from the parents, and the committee amendment adds the provision that the parent will send an annual notification to the Department of Education, and I support that provision, and the homeschoolers were also acceptable. Thank you, Mr. President.
Mr. Clerk, for a motion.
Mr. President, I have MO 1267, 1268, and 1266 offered by Senator Clements, all with notes that he wishes to withdraw.
So ordered. Without objection.
Mr. President, Senator Conrad would move to amend the committee amendments with AM 2677.
Senator Conrad, you're recognized to open.
Thank you, Mr. President. Good evening, colleagues. Good evening, Nebraska. I had an opportunity to be a part of this public hearing as a member of the Education Committee. I think Senator Clements brought forward a very interesting and important issue on behalf of homeschool families in Nebraska. We hear a lot about what's happening in our public schools and, of course, in our private schools as well. We don't hear a lot about what's happening with our homeschool parents and our homeschool families. And just so that people know, the amount of Nebraska families who've decided to homeschool their children has increased over time, and particularly since the pandemic, for a lot of different reasons. And I think it's important that our legal and regulatory framework is modern and is not overly intrusive, and respects and understands that parents have a fundamental right, a fundamental constitutional right to direct the education of their children and their families. That being said, I think that this is one issue that popped up at the hearing. I think there was a lack of clarity when it came to how the proposed legislation may impact family law issues like custody agreements or arrangements or orders. I pledge to work with Senator Clements and others who were working on this measure to try and address that with this amendment, and that is what is before you. AM 2067 amends Amendment 2440 and makes a minor but important change, as it's meant to be an improvement to the bill and its purpose. This addresses situations in which a court has designated one or both parents, or perhaps even another person, with the authority to make educational decisions on behalf of a child. The concern that I had and what had motivated me to bring this amendment would be to prevent confusion in which a court has directed that only one parent can make educational decisions, but the other parent or the school believes that this statute might trump a court order and allow another parent to contravene the existing court order. This could cause unnecessary confusion and conflict with school administrators and parents, and hopefully that would not arise frequently, but just in case, I think there was a lurking family law issue in the original bill, and that was not remedied by the committee amendment. I brought this forward to Senator Clements. I believe he accepts it as a friendly amendment that does not alter the overall intent of his bill, but that is important to bringing legal clarity to these situations. Friends, as you know, most if not all divorce and custody cases award both parents with equal authority to make educational decisions on behalf of their children. This amendment would accommodate and understand that reality. One final note, when it comes to the term educational decision makers, in some circumstances, courts will actually appoint a family member or even a guardian ad litem besides the parents who will be responsible for making educational decisions on behalf of the children. This pops up in cases of abuse or neglect by the parents, and or in instances where the parents cannot essentially carry out that parental duty and educational decision making because of disability or imprisonment or some other obstacle. So that's a note on the terminology. That's a note on the why. I'm happy to answer questions. I appreciate Senator Clements working with me to address this and would urge your favorable consideration. Thank you, Mr. President.
Senator Wayne, you are recognized to speak.
Mr. President, I don't know who pushed my button. I was sitting over there the whole time, so I'll wave, but I support the amendment.
Senator Hunt, you are recognized to speak.
Thank you, Mr. President. First, I want to say seriously, don't push each other's buttons. Like, no, I'm serious. I'm not kidding. It gets late and we're fooling around and we're being funny, but I don't know. I just think we have to have some standards in here institutionally, and it's messed up. I have a question. Would Senator Clements yield to a question just for clarification?
Senator Clements, will you yield?
Yes.
Thank you. Would there, under LB 1027, including these two amendments, were they to be adopted, Senator Clements, could there be a scenario where one parent wants to remove their child from school against perhaps the wishes of the other parent? Would that be possible under this bill?
The amendment from Senator Conrad talks about legal guardian or educational decision maker. We're hoping that the people will have declared an educational decision maker in their divorce agreements, and that it would be possible for a challenge, but I'd say currently the person that is refusing to sign is creating a problem for the person who wishes to continue the homeschool, because that does require litigation. There could be, one or the other could end up in litigation, so I'm not exactly sure if this cures everything, but we're hoping to have this educational decision maker language would help clarify who is in authority.
Okay, thank you very much. I know that in not all divorce decrees, an educational decision maker is necessarily designated. In my divorce, I got divorced maybe 2012, I don't know, a long time ago. And we have a child, and we don't have a educational decision maker designated in our agreement because, you know, it was pretty amicable, and it remains to this day, and we make decisions together about our child's education, and it works fine. But I know that of course, for all couples, that's not the case. And I have heard concerns from constituents about, you know, there is an increase in homeschooling, and I think that most homeschoolers are excellent educators and it works for their families. You know, I can imagine many scenarios where I myself would like to homeschool. But I'm a little concerned about the possibility of a parent removing their child from school without the best interest of their child at heart, and that the other parent may be being against that. And, you know, I'm also sympathetic to the problem that was described by Senator Clements in the opening about, you know, the statute as it is being kind of antiquated. So I guess I'm just looking for some reassurances that something like that's not going to happen. And also before I finish, it's late, you know, last year, some of the funny things that were happening on the floor, like people getting tired, people pushing each other's buttons, throwing candy across the aisle during final reading, talking really loudly and laughing really loudly. Let's not, you know, this is coming from me, I get it. Let's not forget decorum in here. Even when it's late, even when we're tired, we can play lots of pranks on each other that don't, you know, kind of insult or demean the institution. Thank you, Mr. President.
Senator Wayne, you are recognized to speak.
Thank you, Mr. President. Colleagues, I did push my button. I just want to own it. I didn't know I did because we had multiple committee amendments. And so by the time it came to me, I actually thought I got out the queue. So we were over here having a conversation. Let me tell you why I support. At first, I was a not present, not voting on this. And I'll tell you why I'm moving differently is because the one parent is actually the same one parent requirement in all public schools. Right. So if it's good enough for public schools, it should be good enough for any school, that if one parent can move them. My only issue was if there was a divorce or if there's a custody thing, but at the end of the day, no divorce decree or the custody decree at this point should not have a final say provision. If you don't have one, then we need to go back and get one if you're people out there who don't have one. But how it is somebody has legal custody and joint custody for educational decisions, medical decisions, but whoever is, but they always say somebody has a final say. And that's because we kept running into this in litigation. You'd always get brought back for typically around school. But we've always started putting in there, at least for the last 5 years, of all divorce decrees, or custody decrees, who has final say, particularly if one only has joint legal custody, but one other one has a primary physical custody. And then you always leave that final say with the person of the physical custody. At the time of the hearing, there were some amendments, or at exec session, there were some amendments floating around. So I was present, not voting, because I haven't had a chance to read those. But I want to be clear here. This is the same standard right now that Omaha Public School uses and everybody else. So that's why today I will be switching my vote if people are asking why. It's the exact same standard in public schools. Thank you, Mr. President.
See no one in the queue. Senator Conrad, you're welcome to close on 2677. Senator Conrad waives close. Question before the body is the adoption of AM 2677. All those in favor vote aye. All those opposed vote nay. Mr. Clerk.
$38 ayes, no nays, Mr. President, on adoption of the amendment.
AM 2677 is adopted. Mr. Clerk, next item.
Mr. President, I have FA 295 from Senator Clements.
Senator Clements, you are recognized.
I move to withdraw.
Without objection, so ordered. Next item.
Mr. President, Senator Clements would move to amend with AM 3075.
Senator Clements, you are recognized.
Thank you, Mr. President. We found that we needed AM 375 to harmonize another section, 79601, regards the Department of Education inspection ability for exempt schools, but there's a 791605 which allows a superintendent in that area to inspect exempt schools. And this was an oversight on our part. This will also remove the language in 7916. Let me just make sure, 1605, and say that it does not apply to exempt schools, which, and again, a provision which has never been used. Thank you, Mr. President.
Senator Walz, you're recognized to speak.
Thank you, Mr. President. I'm just wondering if Senator Clements would yield to a question.
Senator Clements, will you yield?
Yes.
Thank you, Senator Clements. We had asked you before if you had asked the Department of Education about this amendment and how they felt.
We have not heard back. This afternoon, tried to reach the commissioner who was at a conference, and we've not heard back from him. But so I'm sorry that we haven't, but we definitely will make sure the department is in compliance. If they're not, I'd be glad to remove the provision on select.
Okay, all right. Thank you, Senator Clements.
See no one left in the queue. Senator Clements, you're welcome to close. He waives close. Colleagues, question before the body is the adoption of AM 3075. All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
35 ayes, no nays in adoption of the amendment, Mr. President.
The amendment is adopted. Next item, Mr. Clerk.
I have nothing further on the bill at this time, Mr. President.
Senator Merman, you are welcome to close on AM 2440.
Waive.
Senator Merman waives close. Question before the body is the adoption of AM 2440. All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
37 ayes, no nays in adoption of the committee amendment, Mr. President.
The amendment is adopted. Senator Clements, you are recognized to close. Senator Clements waives close. Question before the body is the advancement of LB 1027 to E&R initial. All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
36 ayes, no nays in advancement of the bill, Mr. President.
LB 1027 does advance. Next item, Mr. Clerk.
Mr. President, General File Legislative Bill 1051, introduced by Senator DeBoer. It's a bill for an act relating to juveniles. Changes provisions relating to filing deadlines, eliminates obsolete provisions, reorganizes and harmonizes provisions, provides duty supervisor statutes, repeals the original section, outright repeals section 43-24704. Bill was read for the first time on January 8th of this year and referred to the Judiciary Committee. That committee placed the bill on general file with committee amendments, Mr. President.
Senator DeBoer, you're welcome to open on 1051.
Thank you, Mr. President. Good evening, colleagues. I stand before you tonight to open on LB 1051 as amended by AM 2641. Despite its length, LB 1051 is actually a cleanup bill and is the outcome of work done on the LR 386 from my interim study last summer. LR 386 introduced, in 2022, we did do this for 2 years, was an interim study to examine the Nebraska Juvenile Code. To aid that effort, a work group of experts in juvenile issues consisting of judges, attorneys, and researchers was formed. They began their work in the fall of 2022 and continued through the summer of 2023. The goal of the work group was to recommend changes to make the juvenile code easier to read, navigate, and to provide consistency across the code. The work group made 6 recommendations, the 3 of which are reflected in LB 1051 are non-substantive. That is, there is no policy change being made by LB 1051. Colleagues, the crazy things which we are doing in LB 1051 are, number 1, providing a topical index to the juvenile code. This recommendation is reflected in section 19 of the bill. Number 2, reorganizing Nebraska Revised Statute 43-248 and 43-250 to flow more cohesively. This change is made in sections 7 and section 8 of the bill. And finally, to eliminate obsolete provisions of the code. AM 2641, the Judiciary Committee amendment, removes one section, section 13, at the request of the county attorneys. This section was included as a conversation starter at the request of the committee that worked on the bill, and was one of the substantive issues that the work group identified. Conversations on that issue are ongoing, and so it has been removed and is no longer part of the bill. LB 1051 was heard by the Judiciary Committee on February 15th of this year with proponent testimony from the Nebraska State Bar Association and the County Attorneys Association, no opposition testimony, and was advanced from committee on an 8-0 vote on March 7th. I want to thank the speaker for selecting LB 1051 as a speaker priority this bill. 1051 is a simple but important cleanup bill to the Nebraska Juvenile Code, which we put in place in order to make our code more comprehensible to those who are reading it. Thank you, Mr. President.
Senator Wayne, you are recognized to open on the committee amendment.
Thank you, Mr. President. LB 51 was heard by the Judiciary on February 15, 2024. The committee voted 8-0 to amend the bill with AM 2641 in advance the bill to general file. AM 2641 strikes the provision section 13 from the introduced bill. Section 13 would have amended 43-255 to change the time limit for a juvenile to be detained, to be released unconditionally if the motion alleging a violation of a court order, a juvenile petition, or a criminal complaint has not been filed. The current law is 48. The introduced bill would have changed it to 24. And so all we're doing is changing it back to the current bill or the current law, which is 48 hours. Thank you, Mr. President, and vote green on AM 2641.
See no one in the queue, you're welcome to close. Senator Wayne waves close. Question before the body is the adoption of AM 2641. All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
38 ayes, no nays, Mr. President, on adoption of the amendment.
The amendment is adopted. Senator DeBoer, you are recognized to close.
Thank you, Mr. President. I want to thank all the members of the work group who worked on this bill, as I said, for 2 years. And I want to make a special thanks to my LA, Brian Murray, who worked with the work group, who shepherded this bill through, whose dedication to his job means that we have a more comprehensive and cohesive juvenile code. And I think that's something that is really important, and I'm very, very thankful for him and his service. Thank you, Mr. President.
Question before the body is the advancement of LB 1051 to ENR initial. All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
38 ayes, no nays to advance the bill, Mr. President.
LB 1051 advances to ENR initial. Mr. Clerk, next item.
Mr. President, next item, Legislative Bill 874, introduced by Senator Bostar. It's a bill for an act relating to child care licensing and child care facilities. Changes requirements for child care licensing, liability insurance for child care license applicants, background checks for child care employees, and the use of blankets to child care facilities. Provides reporting requirements to the legislature for the Department of Health and Human Services, state fire marshal, and municipalities. Provides a property tax exemption, harmonized provisions, repeals the original section. Bill was read for the first time on January 3rd of this year. referred to the Health and Human Services Committee. That committee placed the bill on general file with committee amendments, Mr. President.
Senator Bostar, you are recognized to open on 874.
Thank you, Mr. President. LB 874 is legislation crafted to streamline, clarify, and standardize various state licensing requirements and local regulations under the Child Care Licensing Act to enable child care programs to operate more efficiently and effectively. It was advanced from committee unanimously and enjoys support from First 5 Nebraska, the Nebraska Children and Families Foundation, the Nebraska Farm Bureau, Nebraska Cattlemen, Nebraska Corn Growers Association, Nebraska Pork Producers Association, the Nebraska State Chamber of Commerce, the Greater Omaha Chamber of Commerce, the Lincoln Chamber of Commerce, the Columbus Area Chamber of Commerce, the Platt Institute, and the Center for Rural Affairs. With the committee amendment, the League of Municipalities also supports the legislation. It's clear the demand for quality, safe, affordable childcare is extremely high. It's also clear that recent years have been an extremely difficult period to be a licensed childcare provider in Nebraska. It requires an enormous investment of time, focused attention, and material resources to ensure children's safety and meet developmental needs while operating a financially viable childcare business. In addition to these challenges, excessive regulatory obligations place undue strain on already overburdened childcare providers. Much of current law and regulation effectively ensures the well-being of our children. However, some of these regulations are needlessly burdensome, unnecessarily complicated, and conflict with one another. Our current jumble of child care licensing regulations make an already difficult profession harder than necessary. LB 874 is designed to mitigate some of these challenges. Current regulatory demands come from all levels of government, federal, state, and local. This includes state licensing requirements, separate federal child care subsidy requirements, federal and state background checks, local zoning, building and safety, fire code enforcement, and numerous inspections at each level. There are multiple provisions contained in LB 874, but I'll highlight the most substantive. In Section 3, LB 874 allows dual licenses for child care providers. Enrollment in child care programs can fluctuate significantly throughout the year, increasing during the school year and decreasing over the summer. This legislation allows providers to obtain dual licenses that enable a program to operate under a lower capacity family home child care 2 license when enrollment is down, but return to a higher capacity child care center license when more children are enrolled. This provision will be particularly helpful in rural Nebraska, which rely primarily on family home child care providers. Currently, the Department of Health and Human Services requires previously authorized child care employees to reapply the department for a background check when applying for a position with a new child care provider. Under Section 5, LB 874 allows for the results of the background check to be portable between employers. This does not compromise state and federal requirements for child care background checks. It simply allows the results to be viewed by both a current employer and a prospective employer. This change does not allow background checks to be portable if they are not current. Sections 8 and 9 of the legislation creates a standard 5-year regulatory review that the Department of Health and Human Services and the State Fire Marshal's Office must conduct to evaluate and determine that the current regulations are still valuable and necessary. This is similar to legislation passed by former Senator Laura Ebke for a regular review of small business regulations. This mechanism ensures a process for eliminating outdated regulations and clarifying any issues that arise with new rules. The committee amendment AM 2803 provides cleanup language and strikes Section 7 of the legislation, which prohibits political subdivisions from instituting residency requirements for family child care home providers. This was done at the request of the League of Municipalities, and as I stated before, the inclusion of the amendment moves them into a position of support for LB 874. Regulatory compliance is essential and necessary for the safety of child care in Nebraska. We also want to ensure that the regulatory environment for child care is not needlessly burdensome on an industry that is already struggling to keep programs financially afloat. LB 874 creates a safer and clearer regulatory environment in Nebraska for our child care providers. And speaking as a parent, safety is my top priority. The complexity and confusion in current law doesn't keep our children safe. The clarifications and streamlining of LB 874 improve both safety and access to care. I want to thank Speaker Arch for designating LB 874 as a priority, and I want to thank Chairman Hansen and the Health and Human Services Committee for advancing this legislation unanimously. And I thank my colleagues for their time and consideration. I encourage you all to vote for LB 874 and the underlying committee amendment. Thank you.
Senator Hardin, you are recognized to open on the committee amendment.
Thank you, Mr. President. The standing committee amendment is a page and line amendment that makes two substantive changes to the original bill. First, it strikes the entirety of Section 7, which prohibited political subdivisions from establishing residency requirements for a family child care home. Secondly, on page 13, it removes the requirement for DHHS to submit a report on zoning and ordinances and instead requires the report to be on rules and regulations and renumbers the remaining sections accordingly. As amended, LB 874 was advanced to general file by the Health and Human Services Committee with 7 yes votes, and I would like to ask the body to adopt AM 2803.
See no one in the queue. Senator Hardin, you're welcome to close on the amendment. Senator Hardin waives close. Colleagues, question before the body is the adoption of AM 2803. All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
37 ayes, no nays on adoption of the amendment, Mr. President.
The amendment is adopted. Senator Bostar, you're welcome to close on LB 874. Senator Bostar waives close. Question before the body is the advancement of LB 874 to ENR initial. All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
38 ayes, no nays on advancement of the bill, Mr. President.
LB 874 advances to ENR initial. Mr. Clerk, in consultation with the primary introducer, we'll be passing over LB 71. Please proceed to the next item on the agenda.
Mr. President, pursuant to your agenda, Legislative Bill 1335, General File, introduced by Senator Mosier. It's a bill for enacting the Non-Game and Endangered Species Conservation Act. Defines terms, changes provisions of, and provides duties and exemptions from the Non-Game and Endangered Species Conservation Act relating to transportation infrastructure, harmonizes provisions, and repeals the original section. Bill was read for the first time on January 17th of this year, referred to the Natural Resources Committee. That committee placed the bill on general file with committee amendments, Mr. President.
Senator Mosier, you are welcome to open on LB 1335.
Thank you, Mr. President and Speaker. Good evening, colleagues and fellow Nebraskans. Today, I'm happy to present LB 1335, my personal priority bill this session. It came out of Natural Resources on an 8-0 vote with Committee Amendment 2947. This bill amends the Non-Game Nebraska Endangered Species Conservation Act, NESCA, to provide an exemption from NESCA for transportation infrastructure occurring within the area of any existing road or highway, including any associated right-of-way. The bill states that roads, highways, and their associated right-of-way are man-made structures and not critical habitat. As it stands, without this bill and its amendment, NESCA is more restrictive than the Federal Endangered Species Act, and it has fewer tools for balancing transportation interests and conservation interests than the Endangered Species Act. Under LB 1335, exempted parties are still required to consult with the Nebraska Game and Parks through NESCA for any new areas that they disrupt, but would be exempted from these requirements for subsequent work in the same area. Senator Bosselman will introduce AM 2947, which represents the results of extensive collaboration between the Department of Transportation and Game and Parks. It also adds additional tools that allow for the balance of the state's conservation interests and the needs of the state transportation system. After the introduction, I will provide more details about the modifications in the amendment. I would ask you to vote green on LB 1200 and AM 2508 and pass them on to select file. Thank you.
Senator Bosselman, you are recognized to open on the committee amendment.
Thank you, Mr. Speaker. Good evening, colleagues. As previously stated, this amendment was negotiated in good faith between the Nebraska Department of Transportation, the Nebraska Game and Parks Commission, and other interested parties. It amends LB 1335 to provide additional tools for the Nebraska Game and Parks Commission, clarifies language in the original bill, and cleans up some provisions in the Non-Game and Endangered Species Conservation Act. The amendment creates a process for the Nebraska Game and Parks Commission to permit incidental take of listed species. The incidental take of threatened or endangered species is allowed through a formal consultation process. This valuable tool provides flexibility for all types of projects and their impact on species. It applies to all Nebraskans, not just those engaged in transportation projects. The Federal Endangered Species Act also allows incidental take through a permitting process. This amendment gives all Nebraskans greater predictability by requiring the Nebraska Game and Parks Commission to assume federal incidental take statements from U.S. Fish and Wildlife Services. This amendment also contains a restoration standard for exempted parties on areas temporarily impacted by transportation projects. I ask for your green vote on LB 1200 and AM 2508 and pass them on to select file. Thank you, Mr. Speaker.
Seeing no one in the queue, Senator Bosselman, you're welcome to close. Senator Bosselman waives close. Colleagues, the question before the body is the adoption of AM 2947. All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
$36A is no nays, Mr. President, on adoption of the committee amendment.
AM 2947 is adopted. Senator Mosier, you're welcome to close on 1335.
Just very briefly, in the past, when the Department of Transportation did more work on a road after they had built it, they'd have to get full permits the second time. So they'd offset the first time, sometimes 2 to 1. So if they disturbed 20 acres, they had to buy 40 acres and put that into a permanent easement. And then that's the first time. Then the second time, you know, it might grow up wildflowers or something and look like habitat again. And so then you'd have to offset that and you'd have more permanent easements. So this change in the law allows us to be more conservative with the money we spend on roads. And it should save us tens of millions of dollars potentially. And it could save us a lot of time, because before you had to go to the federal government and let them analyze all your work. And then you had to go to Game and Parks and they had to analyze all your work. And there was always something that one or the other found that we missed. So this really helps. Thank you.
Yes, we're having some problems with the voting system right now. We will be taking roll call vote. The question before the body is the advancement of LB 1335 to ENR initial. Mr. Clerk, please call the roll.
Senator Aguilar. Senator Albright. Senator Arch. Voting yes. Senator Armendariz, voting yes. Senator Ballard, voting yes. Senator Blood, Senator Boston, voting yes. Senator Bostar, Senator Bostelman, voting yes. Senator Brandt, voting yes. Senator Brewer, voting yes. Senator John Kavanaugh, Senator Michaela Kavanaugh, Senator Clements, voting yes. Senator Conrad, voting yes. Senator Day, voting yes. Senator DeBoer, voting yes. Senator DeKay, voting yes. Senator Dorn, voting yes. Senator Dover, voting yes. Senator Dungan, Senator Erdman, voting yes. Senator Frederickson, voting yes. Senator Holleran, voting yes. Senator Hansen, Senator Harden, voting yes. Senator Holdcroft, voting yes. Senator Hughes, voting yes. Senator Hunt, voting yes. Senator Ibaugh, voting yes. Senator Jacobson, voting yes. Senator Kauth, voting yes. Senator Linehan, voting yes. Senator Lippincott, voting yes. Senator Lowe, voting yes. Senator McDonald, voting yes. Senator McKinney, voting yes. Senator Meyer, voting yes. Senator Mosier, voting yes. Senator Merman, voting yes. Senator Raybold, voting yes. Senator Reapy, voting yes. Senator Sanders, Senator Slama, Senator Vargas, voting yes. Senator Von Gillern, voting yes. Senator Walls, voting yes. Senator Wayne, voting yes. Senator Wishart, voting yes. Mr. President, the bill is advanced.
LB 1335 is advanced to E&R initial. Mr. Clerk, next item.
Mr. President, Legislative Bill 20, introduced by Senator Wayne. This bill for an act relating to voting rights provides for the restoration of voting rights upon completion of a felony sentence, harmonized provisions, and repeals the original section. Bill was read for the first time on January 5th of this year and referred to the Government, Military, and Veterans Affairs Committee. That committee placed the bill on general file. There are no committee amendments nor additional items, Mr. President.
Senator Wayne, you're welcome to open on LB 20.
Thank you, Mr. President. Colleagues, this is going to be interesting when you have some people going. We're gonna go with it. I'm not going to go through the whole introduction because it's late. I won't tell you about the history of how Nebraska became a state and how this was the section that was used to veto us not once but twice. But here's what I will tell you. Nebraska is the only state that has an arbitrary, after somebody has finished their sentence, that there's a 2-year arbitrary penalty in voting. I'm going to keep this very, very short and see where we are. Iowa in 2020, through an executive order, decided to reinstore all people who completed their sentence the ability to vote. That's what this bill does. Says once you are done with your sentence, once you have served your time, you are off paper. That means you are no longer on probation, post-supervised release, or parole. You can vote. So essentially, once you are done with your sentence and completed your time, you can vote. Right now, there's an arbitrary 2 years, and we are the only state that has an arbitrary 2 years. And here's why I call it arbitrary, and I'll end with this. This bill was first introduced over 20-something years ago. They decided to put a 2-year limitation because they were worried about some elections. They met underneath the north balcony to the right of me, and they randomly picked 2 years because everybody was comfortable. That is not me saying that. That was Senator Lauren Cruz and others who came and testified at the first year I introduced this bill. This was heard in the Education Committee. It came out of the Education Committee, and I would ask for a green vote. Again, we are the only state, Government Committee, sorry. I said Education because I was looking over here. Government Committee, I apologize, Senator Brewer. But we are the only state left in the country that has this arbitrary. Many states have found these arbitrary things to be unconstitutional. And again, the reason why I call it arbitrary is there's no condition on the 2 years. There's no, you have to be good, you have to do this. It is just a 2 years you can vote. I believe that everybody I've talked to understand that at the end of the day, when you have completed your sentence, when you are done, you should be able to participate in our society fully and completely. And with that, I will ask for a green vote. Thank you, Mr. President.
Return to the queue. Senator Brewer, you're recognized to speak.
Thank you, Mr. Speaker. I want to get up and speak on this bill in particular because I've been around long enough to see it come full cycle from the 2 years now to try and change it. It came through government committee. We had a lot of testimony on it. It came out with full support. I have spent my share of time out at Nebraska State Penitentiary, and I think that there is a point we have to come to the realization that when you've paid your dues, when you've served your time, you have to be able to be allowed back into society, or we're destined to have folks in a constant cycle of going back and forth. So I want to stand in support of Senator Wayne's bill and ask that you would support it also. Thank you, Mr. President.
Senator Raybold, you're recognized to speak.
Thank you, Mr. President. I want to thank Senator Wayne and Senator Brewer as the chair of the Government Affairs Committee. You know, this bill has been around for many, many, many years. And it was interesting when we had all the senators come back today, former senators, and I had a chance to speak to Senator Diana Shimmick. She was the one who had originally introduced legislation so that once you have served your sentence, either probation or parole, that you would have your voting rights restored for any felony conviction. And she tried 3 times. It was on that 3rd time that she wanted it to pass. And so they did gather, as Senator Wayne said, underneath the balcony, just said, how about 2 years? And that's how they came to it. And I want to thank Senator Wayne. He has been consistently pushing this forward. All I can say, it's long overdue. It's a fairness, and I ask for your support on this. Thank you.
Senator Erdman, you are recognized to speak.
Thank you, Mr. President. I appreciate that. So Senator Wayne had brought this bill several times, and I went to the Pardons Board hearing. I guess it was back in maybe September. I'd never been to one of those before. I had an opportunity to listen to the issues that these people had gone through that were asking for a pardon. And I came away from that hearing with a different perspective about what it means to pay the penalty that you were charged to pay. And I had voted for this bill a couple of times. I think the last time I didn't vote on final reading, but I've changed my opinion, and I just sent a note to Senator Wayne, told him I'm going to vote for this amendment for this bill. And so I would encourage you to consider that as well. And I think it's time for us to catch up with the other states. So I know we can't vote green, but at least vote yes. Thank you.
Senator Hunt, you are recognized to speak. Senator Hunt waves. Senator Clements, you are recognized to speak.
Thank you, Mr. President. I do not agree with this bill. I'm not going to support it. I've voted no in the past. I think somebody should wait 2 years to make sure that they haven't gone back into criminal activity, and that in the past, I'm sure in the past, the felony conviction, you lost your voting rights for life. And then I think it was 10 years, and now 2 years, I think is still reasonable. So I'm not in favor of this bill. Thank you, Mr. President.
Senator Lowe, you're recognized to speak.
Thank you, Mr. Speaker. Senator Brewer made a comment when he spoke that it came out unanimous. I do want to make the record clear that there were 2 no votes for it coming out, Senator Halloran and myself. Thank you, Mr. Speaker.
Senators, with our system down, I want to make sure that everyone has an opportunity to speak. If you do want to speak, please come forward and identify yourself. Senator Raybold, you are recognized to speak.
Thank you, Mr. President. I want to say that in the committee, we had 14 testifiers who came in support of passing this, and we had 1 speak in opposition and 2 were in neutral. But then the online comments, we had 78 people respond in support and 5 in opposition. So I wanted to say that there has been a great debate and discussion during the committee. We've seen veterans and people that have done service to our country who've gotten in trouble, got sentenced, convicted, and served their time, did probation and parole. It's time that we allow them to have the full right of democracy that some of our veterans have fought so hard for. Thank you.
Senator Halloran, you are recognized to speak.
Thank you, Mr. President. As Senator Lowe pointed out in the committee, I did vote no. That's true. But I have since reconsidered. Sometimes you have to put yourself in the position of someone that has served their time in prison for whatever purpose they had to serve it for. Sometimes you have to put them in their shoes. It's called empathy. And that's what I've done. I've tried to imagine being in that position. So I have changed my position on this. I'm supporting this bill. Thank you.
Are there any other senators? I don't want to cut this off short. Any other senators that would like to speak to this bill? See none. Senator Wayne, you are recognized to close.
Thank you, colleagues, and I know it's late, and I know people are scrambling, and I know we want to get out of here. I really appreciate Senator Brewer, Senator Erdman, Senator Halloran, and yes, even Senator Clemens and Senator Lowe for speaking on this, because all of them have been engaged. I've been talking to Senator Clemens about it. I've talked to Lowe about this for 8 years. So regardless of where the vote is, I just appreciate people being engaged and people talking. I think it's how we get better bills and how we get things done. So I would ask for a roll call vote, Mr. Speaker, Mr. President.
Question before the body is the advancement of LB 20 to ENR initial. Mr. Clerk, please call the roll.
Senator Aguilar, Senator Albright, Senator Arch, voting yes. Senator Armendariz, voting yes. Senator Ballard, not voting. Senator Blood, Senator Bosson, voting yes. Senator Bostar, voting yes. Senator Bostelman, not voting. Senator Brandt, voting yes. Senator Brewer, voting yes. Senator John Kavanaugh, Senator Michaela Kavanaugh, Senator Clements, voting no. Senator Conrad, voting yes. Senator Day, voting yes. Senator DeBoer, voting yes. Senator DeKay, voting yes. Senator Dorn, voting yes. Senator Dover, voting yes. Senator Dungan, Senator Erdman, voting yes. Senator Frederickson, voting yes. Senator Halloran, voting yes. Senator Hansen, Senator Hardin, voting yes. Senator Holcroft, voting yes. Senator Hughes, voting yes. Senator Hunt, voting yes. Senator Ibaugh, voting yes. Senator Jacobson, voting yes. Senator Kauth, voting yes. Senator Linehan, voting yes. Senator Lippincott, voting no. Senator Lowe, voting no. Senator McDonnell, voting yes. Senator McKinney, voting yes. Senator Meyer, voting yes. Senator Mosier, Senator Merman, voting yes. Senator Raybold, voting yes. Senator Reapy. Senator Reapy, I'm sorry. Voting yes. Senator Sanders. Senator Slama. Senator Vargas. Voting yes. Senator Von Gillern. Voting yes. Senator Walls. Voting yes. Senator Wayne. Voting yes. Senator Wishart. Voting yes. 1 second. Mr. President, 34 ayes, 3 nays on advancement of the bill.
LB 20 advances to E&R initial. Mr. Clerk for items.
Mr. President, your Committee on Nebraska Retirement Systems chaired by Senator McDonald reports Legislative Bill 686 to general file with committee amendments. Name added Senator Vargas, name added to LB 2, Senator Vargas to LB 686 and 1082. Senator McDonald, name added to LB 1284. Finally, Mr. President, a priority motion. Senator Raybould moved to adjourn the body until Thursday, March 21st, 2024 at 9:00 a.m.
You have heard the motion. All those in favor say aye. All those opposed, nay. We are adjourned.